Do you have the act with you?
You can say.
Please read it. Read. Mhm. Section 50.
Character as
Read a little louder.
Lordship.
Read a little loud.
Lordship. Character as affecting damages. In civil cases, the fact that the character of any
What are you
person.
reading?
Lordship,
I asked you to read section 50 of the Evidence Act.
55, Lordship. Sorry.
Why are you
Lordship.
reading 55?
Sorry, Lordship. Opinion and relationship when relevant. When the court has to form an opinion as to the relationship of one person to another.
So now you are trying to claim that person is your father. That is,
Yes.
you are claiming relationship.
Yes.
Now read further how it is to be done.
The opinion expressed by conduct as to the existence of such relationship of any person who is a member of the family or otherwise.
So, family or otherwise.
Yes, Lordship. Has special means of knowledge.
So either a member of the family or otherwise means anybody else must have special means of knowledge.
Yes, Lordship.
So does your Gaon Panchayat secretary have any special means of knowledge?
Lordship, as a local,
Does he have special means of knowledge? Does the section 50 also provide for local?
Yes.
It does not provide.
no, Lordship.
Then it has no value under the law. So
Another certificate was issued by the governor of.
you may
local
bring
village.
any number of certificates.
Yes, Lordship.
Unless the person has special means of knowledge of the fact,
Yes,
it is of no use. Find out anybody who has special means of knowledge and bring that evidence of that man.
Lordship.
Lordship, another thing is at page 28, when that information was sought from her by the police, Lordship, father's name was not furnished. It is there in the form. Never given, Lordship.
There is a possibility that the person could not decide who is the father at that relevant point of time.
And this is,
So later on, the father,
That was Lordship investigation report, Lordship.
so investigation.
Never
what-
disclose her father's name. Notice was issued against Forzan Nessa, Lordship. I am Kobzan Nessa.
very well.
This is very interesting, Lordship.
So we impose a cost on you for trying to manipulate the system. You deliberately did not say the name of the father, either on the advice of somebody or on your own. That don't give the correct information. So later on, when the case will be filed, we can take all these steps. This
No.
is a very bad practice, Mr. It cannot be appreciated. If there is an inquiry, the inquiryman asks the name, give the proper name, correct address. By misleading the inquiry, later on, how can you take advantage of your own misdeed?
Lordship, suppose the inquiry officer had not come. to-
Mr. Hussain, you are in bigger trouble if you are trying to justify this act. Then not only you have done one illegal act, now you are again trying to justify that illegal act by again bringing in strange thinkings. Go and prove yourself, declare who is your father, go and prove your citizenship.
Kindly allow time.
So now you claim somebody to be the father. Very well. We have no views to express on that. But you, as required under section 50 of the Evidence Act, you prove that that man is your father.
special.
Mr.
knowledge.
N. Hussain and counsel for petitioner seeks for an adjournment to produce any relevant material which may prove that Afzal Khan of Balikuti NC is the father of the petitioner. And the learned counsel in course of his argument has taken note of section 50 of the Evidence Act.
Obliged, please.
Item 4.
Yes, item 4.
Right, please, your lordship.
To show that Amjad Ali, son of Jainal, is also a citizen.
So, lordship, the name of the father of the petitioner, your lordship.
Is Amjad Ali,
Amjad Ali,
son of Jainal.
first did appear, your lordship,
Uh,
in the year 1985, your lordship.
we know.
Lordship.
So now how he is a citizen?
So, lordship, my responsibility.
Don't raise an argument. Tell us the relevant material which will show that he is a citizen. These are not cases of argument. First you establish the facts, then you raise your argument. We'll definitely hear you.
Lordship, I beg to.
But before raising the facts, if you raise an argument,
So, lordship, I beg to, lordship.
beg to differ on that.
Page
That-
40, may I kindly be looked into. lordship.
What is that?
Page 40, lordship, may I read you, lordship?
Yes, so what does it contain? Don't you tell us.
Because you, lordship, there is a Khotian, you, lordship.
Sorry?
There is a Khotian.
Khotian,
Khotian, in the name of the father of the petitioner, issued in the year 19.
page number
Page number 40, may I kindly be looked into, your lordship.
40
40 of the judgment, your lordship.
of the judgment we are not relying. If you are relying on the judgment, why are you before the court?
But
You accept the judgment.
the lordship,
Judgment cannot be evidence.
so lordship, I have the cell deed, your lordship. They have
Bring it,
recently
bring
filed
it.
your lordship. But without lordship's permission, your lordship, I have not
You
annexed.
don't have to take any permission, you bring it before the court. if you
Lordship,
have.
this cell deed is there, your lordship, because I get it, your lordship, because they have furnished it recently, your lordship. So it has been
Show
issued.
it to. Can you read it?
I can always
In-
take the help lot.
Uh-huh.
I can read you, lordship. Nasa message.
No, let Mr. Ali read it.
Kitya sale we did it.
A to 61.
You had shifted the burden of reading to us. Barabar Abdul Kalam, Peter Manik Sheikh. Who is the father?
Amjad Ali, your lordship. Because cell deed is in the name of two brothers, your lordship.
Who are they? Itu Barabar Abdul Kalam, Peter Manik Sheikh. Zati Musulman, Pesa Krisi, Jopeya, Borai Salah. Itu কি দিছে আকৌ বৰাবৰৰ পৰা এটা নাম আৰু বৰাবৰে তাৰমানে আৰু নেকি
না, এইটো মই দিম।
গোৱালপাৰা বৰাবৰে মোহাম্মদ রহমান মন্ডল
94 issue করেছে না?
গনি ইপসহি মোহাম্মদ আহমেদ
70
আমজাদ আলী মন্ডল বরাবর কি লিখে মানে what does it mean? What does it mean, this one? Barabar Muhammad Abdul Kalam Pita Manik Sheikh Zati Musalman Pesa Krisi Hang Jopeya Borai Salah.
Barabar is the seller, is it? Barabar is the seller.
We are not asking you to educate us. Everybody knows Barabar is the seller. We are asking the further contents.
Lordship, lordship. Sorry.
Zila Gwalpara Then it is saying Borabare. Barabar so and so, complete address, then Borabare. Tipsohi Muhammad Rahman Mandal. Something not readable, Goni. Tipsohi Muhammad Amjad Ali Mandal. Arikibata Goni. What does it mean? What is the second Borabare? Now tell us that meaning. First Borabare we understood, it's a seller. What is the second Borabare? First Borabare, seller, a distinct name with complete address is there. After writing that name, Borabare, two more names, Tipsohi. No identity, father's name not there, residence not there, nothing is there. What does it mean, this kind of a sale deed? Are they also sellers?
Lordship, so far the inspection derived to lordship.
We don't go by instruction, we go by the facts presented before the court. Why not?
Because this sale is in the name of two brothers, your lordship, including the father of the property, your lordship.
This
Father
is
of the-
precisely we are asking you after reading this sale deed. And an explanation cannot improve the matter if the core fact depicted in the sale deed does not indicate it so. You can read, you can ask anybody else to read, or you read yourself. First name is okay, Barabar so and so. The complete address is there. What about thereafter Borabare? This is where you can help us
Lordship.
to give a meaning to the second word Borabare. What is it?
Yes. Yes. Style of beauty.
Any idea, Mr. Jasim Ahmed? What is the second word Borabare after Borabar so and so?
Actually, sometimes what happen, Barabar and next, it should be seller, but Barabar sometimes use.
No,
Barabar.
no. No,
Barabar,
no,
Barabar.
other, no, the purchaser is separately mentioned. You don't have to think that way. Next paragraph,
Giving the signature.
if he is not a party, how can there be a signature? See, Mr. Ali, it is possible that one plot of land may be purchased by more than one person. Then it will be Barabar X and Y
X, Y,
and Z as it goes on.
but this is Abdul Kalam.
But
But
the-
here, I found that Barabar put his thumb impression. That is why Barabar thumb impression.
Whose thumb impression?
Muhammad Rahman
But it's Abdul Kalam.
Abdul Kalam.
Abdul Kalam is the purchaser.
Huh,
Barabar is the purchaser because Abdul Kalam name is there, but
definitely. Abdul Kalam can give thumb impression, no difficulty with that.
we don't need to check.
Rahman Mandal. He is the purchaser.
No, this is a seller.
Likita.
Likitong is a seller. Likitong is a
He is the Rahman Mandal.
Hmm.
And thumb impression is Rahman Mandal. It is mentioned.
Who is Rahman Mandal?
He is the.
Roman Mondal is a seller, you know.
Seller.
Borabore Tipsohi Mohammad Rahman Mondal. Is a
And,
seller.
and no, what is the first name? Barabar?
Borabore is a purchaser, it is Abdul Kalam.
Ha. Abdul Kalam is a
It's a purchaser.
purchaser.
Abdul Kalam was a purchaser, but.
Roman Mandal is the
Roman
seller.
Then what is the second paragraph? Name in the second paragraph?
Muhammad Rahman Mandal.
লিখিত এক নম্বৰ মোহাম্মদ লিখিত এক নম্বৰ মোহাম্মদ ৰহমান মণ্ডল দুই নম্বৰ মোহাম্মদ আমজাদ আলী
So he is the
they are the লিখিত they are the
Seller.
seller.
sellers
Ah.
and বৰাবৰ
So- So in the first word, Borabare, what does it mean?
they have written বৰাবৰে টিপছহি মোহাম্মদ ৰহমান মণ্ডল
So why would it be put in the column of the purchaser then? If he is a seller.
and other one is টিপছহি মোহাম্মদ আমজাদ আলী
Seller. Two seller. And both the persons put their thumb.
Understand, why will their name be also mentioned along with the purchaser then if they had used it?
Because it's a certified copy, your lordship.
Certificate,
In the
original is-
original, it would have been more distinct how they have put their.
Get the
thumb
origin.
Lordship,
You can bring the original.
later on, your lordship. What happens is that, your lordship, this sale deed is issued in the year 1961, your lordship.
No,
So this-
it is registered in 1970.
Lordship, with respectful submission, lordship, because the sale date is in the year 2060, 1961.
Mr. Dewan, how can you respectfully submit when it is specifically sealed and signed that it is registered in 1970? How can you claim it is of 1961?
Lordship, because it was lost, your lordship. It was lost and again obtained the
No.
certified copy on 12/8/1994. That is what your lordship is indicating.
10/9/1970, your lordship.
It's not 1990, it's some 1970. 70 is the-
10/9/1970.
And that is the date,
Certified copies of 2012.
and that is the date of the registration, I believe.
Certified copies of 2012 lordship, it was.
Revenue Department.
Yes, even the back.
Mr. A. Dewan and counsel for the petitioner relies upon sale deed,
10/9/1970.
which he claims to be of the year 1961. But the seal of registration produced in the copy before the court is of 1970. Again, it is stated that the certified copy was applied in the year 2012. And the contents thereof are also not clear. A copy, the copy of the sale deed produced before the court be handed over to the learned counsel for the revenue department, who shall obtain the necessary information from the,
We can.
you can also do it. To MS, you asked and counsel for the deputy commissioner, which district?
Dhubri lordship.
Dhubri,
My lord.
to get the sale deed verified and authenticated
My lord.
from the original records maintained in the
My lord.
office. List on so and so, the copy is accordingly handed over to MS Yudas.
This copy lordship.
Sorry?
original. Xerox copy.
No, this one.
This one. Xerox copy. Original. I'll have Xerox copy from.
What? Then they can, it'll be better now, all
Mala.
some seals and everything is there on the backside.
Mala.
You
At
keep it
extra copy
safely.
get- My lord.
Keep it safely, don't
Mala.
you?
No, itu original verify আপুনি লৈ ল'ব আৰু মোক এটা কপি দি দিব মানে after vacation
Or you want a Xerox copy?
মানে
It will Xerox
Xerox
কৰি দি দিব।
later মানে if it
The copy provided, the copy or sale deed provided is kept in the custody of the court master, and the photocopy of both sides of the sale deed be provided to MS Yudas.
Oblige you, sir.
Item 5.
Photocopy কৰি দি দিব।
My lord, item 5, we have communicated, it will be registered by the today.
One sometime.
Yes.
Adjourned on the prayer of Mr. J. Pine, then counsel for the Home Department. Oh, there is no.
Item 6.
Yeah, please, Your Lordship. Lordship, kindly peruse the order dated 9/6/2023, Lordship.
Education produced the complete.
Lordship, that is the complete voter list of the year 1966, 71, 85, and 97.
Election department, liquid education department. So go to know for it. You have got it?
Yes, sir.
Have you read the list?
Yes, sir. I have seen the list.
What does it indicate?
In petitioner, father is your lordship, Morabullah Sheikh.
Petitioner relies upon the voters. Name of Baburullah Sheikh,
Grandfather, Your Lordship.
Ah.
Grandfather name is
son of Dhiro
Barabullah Sheikh.
and Neto Bibi, wife of Barabullah.
It is in page number 2, Your
Claimed that Barabullah is the grandfather. Niyamat Ali, son of Barabullah of the 70th, whose name if he was a name.
In 1970. Your
Well,
Lordship.
Mr. Is for the motion.
Motion.
I'm petitioner বাকি দিব। Petitioner relies upon the voters list of 1966 of Village Tindurai Part 2, which contains the name of Baburullah Sheikh, son of Dhero, and Neto Bibi, wife of Baburullah, at serial number 128 and 29 respectively. And it is claimed that Baburullah is a grandfather and Neto Bibi is the grandmother of the petitioner. (1971) voters list of Village Tindurai Part 2 contains the name of Niyamat Ali, son of Baburullah, along with Baburullah and Neto Bibi, and it is claimed that Niyamat Ali is the father of the petitioner. The voters list of 1997 of Village Tindurai Part 2 contains the name of Ambia Khatun along with Niyamat Ali, and it is claimed that accordingly the burden under Section 9 had been discharged by the petitioner. What do you do? Send back or notice?
Tapes are there along with that.
Lordship, they send it back and they may produce these before
This,
the tribunal, Lordship.
পঠিয়াই দিয়ক আৰু কিয় মিছা notice use কৰে। প্ৰথমখিনি লিখি দিব। In the এইটোৱে হ'ল। As required by the order of 9/6/2023, the election department has produced a complete voters list of Village Tindurai Part 2 of the years 1966, 71, 85, and 1997. Upon examining the complete voters list, the aforesaid information is found to be correct. In view of the above, remand back to the tribunal to examine the voters list and pass a reasoned order. The Home Department may submit a report as to whether Ambia Khatun of the 1997 voters list and the writ petitioner Ambia Khatun are one and the same person.
And that impugn order might be second. Discuss order. Impugn order, Lordship.
Yes, my Lord.
We are not setting aside whatever order is passed, that will prevail over the earlier order. So, in fact, has the same meaning.
Item 7.
School register was called for by.
Admission register of which year?
Which are
88,
1988, 89.
Sorry,
1988, 89.
1988, 89. That is not a register of 1988 and 89.
That's the, my lord, first.
We can make it out from here only
Lordship.
Your lordship,
that is not a register of 1988 and 89. You don't have to show it. It is not.
Yes. What are the handwritings are also, my lord, it is.
All the
No,
handwriting
no,
of-
that book itself is not that old.
Yes, my lord.
Forget about the contents.
From the first page to last page, all the handwriting are same.
Pursuant to our earlier order dated 12/6/2023, MSB Decca and Council for the Education Department has produced the admission register, which the authorities claim to be the admission register in original of Rupohi Bhokatgaon Muktab School. Look at the admission register itself, makes it discernible that it cannot be a document of the year 1988. Secondly, it is also noticed that that there is a possibility that the entire register had been filled up in one go, because the handwriting from the first page to the end page of the register are same and appears to have been written in one flow. In view of the above, the district elementary education officer Nagaon to register a case before the which police station?
Rupohi.
Rupohi has a police station. Before the Rupohi Hat police station to make a thorough inquiry on the originality and authenticity of the admission register produced before the court. The admission register is returned back to MS B. Decca, Land Council for the Education Department, for handing it over to the DEO, who may, while raising the police case, hand it over to the concerned police official. And interim update of the investigation regarding the authenticity be produced before the court on the next returnable date. Update by the officer in charge of so and so be produced.
Public.
To register a FIR, to lodge an FIR.
Item 8.
So this is the 10th admission register. Out of the 9 were found to be unacceptable and 1 was found to be authentic till now. This is the 10th register we examined. Yes, what is Sumitra
Father-
Das, page number.
Father, page number lordship, 34. 66 voters list.
The police, the police while investigating the matter shall take appropriate action against all such persons who may be involved in the fraudulent act of manufacturing the register. Page number 36.
34 lordship,
Hmm,
34.
34.
Yes, lordship. Village number 2, Doronga.
Doronga.
Just do not the other way, no?
So
Forest,
Makhan Arya,
no, Makhan is grandfather,
grandfather. Kumudini,
Then
grandmother, and
grandmother.
Forest Arya is the father.
father.
Petitioner is Sumitra Das.
Sumitra Das.
Which document will show?
Then brother adduced evidence, lordship.
The name of brother and Forest together,
Yes, lordship. Page 40.
page 40. Same Doronga.
Yes, Doronga. 97 voters list.
Sukumar Arya.
Yes, lordship. Sukumar adduced evidence.
We admit an interim. Third MSB Ghost and counsel for the petitioner also. No? The petitioner Sumitra Das had been referred to the foreigners. In the writ proceeding, the petitioner relies upon the voters list of
66.
1966.
Yes, lordship. Page 94.
1966 of village number 2 Doronga in the business subdivision, which contains the name of Makhan CH Arya at serial 281, Kumudini Bala Rajya at 282, and Paresh Chandra Arya at 283, and it is claimed that Makhan Chandra Arya is the grandfather, Kumudini Bala Rajya is the grandmother, and Paresh Chandra Arya is the father of the petition. That Kumudini Rajya or she is also Arya?
Arya, lordship.
Because same words, if you
A should
write the
have-
A before and the R later, it will becomes
Yeah.
Arya only. No? Good spelling progressive today. Reliance is also placed on the voters list of 1997 of village number 2 Doronga, which contains the name of Paresh Arya and Sukumar Arya. Where both are shown to be residing in the same house number 110. It is claim that Sukumar Arya is the brother of the petitioner, and as his name appears along with Forest Arya, a prima facie indication is also available. Sukumar Arya deposed at DW.
DW2 Lordship.
And
page
stated
62.
before and gave the evidence that the petitioner Sumitra Das is his sister as well as is daughter of Forest Arya. Prima facie case.
DW.
Item
SP
9.
border, Borpeta. Borpeta, SP border.
SP Border.
Border.
Sonabhan Nessa. Who is the father of Sonabhan Nessa?
Nizamuddin.
Page number.
Nizamuddin,
Page number.
page number. Page number 44, my lord.
Sorry.
44.
Budur Chor Nizamuddin is the father.
Yes, my lord, and Rabia
And
Khatun
the
is mother.
petitioner is Sonavan. Which document will show? Sonavan is the daughter of Nizamuddin.
My lord, annexure 35, page 35, my lord.
Page 35,
No, sorry, my lord, 66.
66.
Hanagular page 68, my lord.
What is this? Some Jamabandi?
Yes, Sita Gopi, my lord.
It's a land Buruchor. Sonavan Nessa Nizamuddin. Does it admit? The petitioner Sonavan Nessa had been referred to the Foreigners Tribunal number. Where is the order? Oh, no, Iman to Nalagyan, maybe in the writ proceeding, the petitioner relies upon the voters list of 1966 of village Buruchor in the Gwalpara district, which contains the name of Nizamuddin Sheikh, son of Muslim Sheikh at serial 807. Petitioner also relies upon a Jamabandi, relies upon a Chita for surveyed villages in respect of a plot of land at village Buduchor, which contains the order of the circle officer dated 6/3/2019, by which there is a mutation in favor of Sonabhan Nessa, daughter of late Nizamuddin Sheikh, amongst others, in place of Nizamuddin Sheikh in respect of the plot of land at village Buduchor.
Item 10.
Then
Please, your lordship.
Jahanara Begum, who is the father?
Samsul Haq Loscar, lordship.
Hmm?
Samsul Haq Loscar,
Page number.
page, lordship. You can what,
Page number.
the
In which
Voter
page
list-
you will
voter list
find his name?
1966. Voter list 1966, page 19, lordship.
Page number 19.
Yes,
Samsul Haq Long.
Yes, lordship. Loscar.
Actually, it should be lost score. Where is the vernacular?
Vernacular, page 21, sorry. 19,
Samsul Haq lost score. Is the father.
lordship.
And which document will show is the father?
School certificate, and that school headmaster was examined as DW3 and father was examined as DW2.
Father examined.
Yes, lordship.
Except the father's evidence. Then
School certificate, Lordship would just like to,
school certificate, one more register and one more fake.
at least we will know where we are, Lordship, how we stand with these matters.
No, let we, time being, we pass the interim on the basis
Yes,
of the
sir.
father's evidence, but also to produce the school.
School certificate, yes, Lordship.
relies upon the voters list of 1970 of village Dokhin Loskor Pathar, which contains the name of Samsul Haq Long at serial 298. It is stated that Samsul Haq Long had been written in a short form, which otherwise is Samsul Haq Loskor. This may be right because the village itself is Loskor Gaon.
Okay.
Name of the village itself is Loskor Gaon, so must be Loskor only.
All the voter list
Mhm.
village is same.
Uh,
All the voter list and all documents village is same. Lordship.
Loskor Pathar, not Loskor Gaon, Loskor Pathar. Petitioner relies upon the evidence of Samsul Haq Long as DW2, wherein he states that the petitioner Jahanara Begum is his daughter. In view of the premise, further reliance is also placed on a school certificate,
Page 32, Lordship.
uh,
Page 32.
52,
32.
32.
No,
School
that's a
certificate issued by the headmaster of Dokhin Loskor Pathar Jakaria Mokhtar School, which contains the information that Jahanara Begum is the daughter of Samsul Haq Loskor of Dokhin Loskor Pathar. The education department may produce the admission register in original of Dokhin Loskor Pathar pertaining to the period prior to the year pertaining to period 1991 and prior. Full stop. However, in view of investigators,
Copy of this order to the.
copy of the order to MSB Decca.
Obliged, Lordship.
Item 11. This is expertly order, my lord.
It will be the 5,000.
2000, my lord.
Sorry?
2000 my lord.
Then we dismiss this petition.
My lord, lordship, it's up.
Then why don't you come to 20 rupees?
No, lord, petition is actually very much poor.
Sorry. We understand.
Petition is very much poor, my lord. Only
Every day the same thing we are saying. Poor doesn't mean you will abuse the process of law.
my lord, I admit, it is decent order, my lord.
Ah.
The order is recent, but the reference is of 2005, Lordship.
So feel a
Very
little
much
bit of
aware of
pinch
the
only,
order.
then you will rectify yourself. Otherwise,
Lordship.
if you impose a very low cost, again you will do the same thing. Come back. Say next time instead of 50 rupees, I'll give 100 rupees.
No,
And
my
you
lord.
will be-
It
You won't make this
acceptable. Cannot-
It has been quantified, let it be.
Advocates benevolent.
Can we
Fund.
do it? I think it can be done.
Yes,
There's
it
no
can be.
prohibition.
There's no bar to it, Lordship.
Advocates benevolent fund দিয়া তার তো কোনো বাধা নাই। Just explore this aspect, whether it can be given there or not, and tell us.
We can speak to senior counsel Mrinal Chaudhary. because
No,
he's in the-
you please do
Yes.
it and tell us
I will not.
whether it will be legally permissible or not.
Okay.
If not, we should not pass these orders.
Can I speak?
We are doing it only because a request was made by Mr. Chaudhary that. Bar to কোথায় গেল না লাগে? There should not be any bar, but still, as a precaution,
For
you.
the benefit of the lawyers, Lordship, it seems because
Yeah,
at
that's what he
times
said. He
Yes.
openly he said in a meeting as in the court.
some lawyers are
For the
facing lot of
interest of,
hardships.
definitely,
Yes,
we
Lordship.
appreciate that. We understand it also. And the legal service is already having enough fund of its own. So instead of again depositing it there. But please check up and tell us.
I will, Lordship.
Otherwise, we same order.
Cost of 5,000,
5,000.
Lordship.
Okay, 4,000. But you have to show documents that you are a poor person. Apart from your statement, how do you know the person is a poor person? Or else we'll ask the police to make an inquiry.
No, my lord. It was not been enacted.
Mhm. We'll ask the police to make an inquiry whether the person looks like a poor person or not. Yes, sir.
Yeah, I should
Full
call
point of
them.
payment.
Obliged, my lord.
Item 12.
Poor people come in cars to school.
Yes, Mr. Who is the petitioner? Azad Ali or Azad Ali or Kalam Azad?
Azad Ali is my actual name.
Then why you have written the other two names?
Because in the first voter list, my name was entered as Abul Kalam Azad, Kalam Azad.
Where is it? Which page?
Page 29 mechanism.
See, normally, Mr. Alim, only people who try to escape the law, they have more than one name. People who are willing to subject themselves to the law normally has only one name. So that itself shows some doubt. Moment you come with three different names. Yes, anyway, page number.
Page number 29. The age is also wrongly recorded as 12, my lord.
12 years. It cannot be 12 years,
Yes, my lord.
definitely.
It should be 18.
This is of 1993. Son of Sattar.
Sattar, Abdul Sattar.
Okay. Now, where is the voters list of Sattar?
Page 25.
25.
Sadegh Ali is the grandfather, Abdul Sattar father, and Akimon Nasar
And
mother.
no, Acha, Sattar is the father. Sattar is there in the other one also. 93. Relies on the voters 1970 of village Hontoli.
Malibari.
But
Do you know
second
Malibari?
one is of which village? Malivari. Malivari and Santoli are different.
Village is not Santoli, my lord. Mauja Santoli.
Moza Santoli. What is the village?
Village 2 number Malibari.
Acha, Malipatha.
Malibari.
There's on the voters of village Malivari of 1970, which contains the name of Sadegh Ali, son of Munsi at serial 1, and Sattar, son of Sadegh at serial 2. It is claimed that Sadegh Ali is the grandfather and Sattar is the father. The voters list of 1993 of village Malivari Bathar contains the name of Kalam Azad at serial 163 and Sattar, Kalam Azad, son of Sattar at serial 163 and Sattar, son of Sadegh at 164. It is stated that Kalam Azad of the 1993 voters list is the petitioner himself. It is thought to be explained that although the petitioner is Azad Ali, but his name had been wrongly recorded at Kalam Azad in the 1993 voters list. Keeping the said question open and on understanding that the explanation of the petitioner that Kalam Azad and Azad Ali are one and the same person, we are inclined to issue the interim order for the present. Full stop. But however, in course of the hearing, the petitioner shall produce the complete voters list of the years 1970 up to 1993 or thereafter of village Malivari Pathar, and also produce relevant material to substantiate that Kalam Azad of the 1993 voters list and the petitioner Azad Ali are one and the same person. You bring whatever you have. For the time being, we are.
2011, 2018 is in order, and 2013 is seals it because he has the epic, but before that, it cannot be two persons at the same time, Lordship. He cannot be Kalam Azad and Azad Ali together. Because only when he is regularly
The complete voters list of village Malibari Pathar from 1993 onwards be also produced by the Election Commission to examine as to whether A Kalamajad, what is the name? Madam Verma,
Yes,
A Kalamajad,
A Kalam.
and whether the name of A Kalam Azad continued to appear in the voters list as A Kalam Azad, or the same name was later on depicted as Azad Ali.
They're shifting also. One is from Nunmati, one is from Dispur. Since he's regularized, it is from Dispur Lordship, Dispur constituency, 2011 and 2018. And Epic is also from his, this address, Dispur address.
My lord, to establish the link, I have examined my brother.
Mr. There's nothing called link and all. It is fact. There's nothing called link.
My
Link
are there.
is something already existing that you are only showing it. Here is a case, these proceedings have to show the existence of the fact. That's all.
Regarding the name discrepancy also, my brother has clearly deposed before the tribunal.
Suppose Madam Verma now clears that you are not only A Alim, you are also something else. Will you become the other person also? Madam Verma is ready to clarify, clear it. That you are not only A Alim, you are also, say, take up any other name. Will you become that other person?
No, my-
Merely because she will clarify it.
In the subsequent voter list, my name is appearing Azad Ali. And
That is because
regarding-
that's the correct
I
voters
think
list.
there,
I also submitted
Mr.
it.
Alim, we'll have to hear you something more. Recall the interim order. The relevant
Sorry,
materials may be produced.
And even
We
like
have to
it
hear
will be
you.
shifting also Lordship from Boko to Nunmati.
Further,
to
the
Dispur.
petitioner to also establish that there was shifting from village,
One is from Boko, the first one which is. relying
from
on
Malivari
Lordship.
Pathar to Boko
Yes.
to Nunmati to Dispur.
Yes. To bring the linkage from two different places is come to Dispur. Dispur is his final destination.
Boko village.
Ase to police station Boko,
Police
village.
station, Boko, village Malibari.
That is what.
Oh.
Lordship
Village-
Okay,
said.
Boko to delete karo baro.
That is,
ঠিক আছে, নাহলে ঠিক আছে। Okay, delete one. You prove at least 3 shiftings, not 4.
One shifting from Malibari to Guwahati.
Nunmati, first it is
Nunmati, yeah.
Nunmati and Nunmati to Dispur Lordship. That is at page 32 and
Okay,
34.
yes, list on next week,
After 2 weeks.
after 2 weeks, list after 2 weeks. Hey, notice এখন না লাগে, let it remain in motion to bring the document.
Item 13.
13 is also yours. 16.
But this matter is related to custodial debt.
Sorry.
Custodial debt, my lord.
Custodial date. अच्छा, different matter.
Although this is the old case, my lord, we have received the instructions in the meantime. I received the instructions from Deputy Commissioner yesterday.
You want to file affidavit?
Give me 1 week time. We'll file
Mr. D. Nars and Sinigan Advocate, APM for respondents, praise for
I need 1 week time.
a week's time.
Lordship, before vacation, I will file.
A week's time to file the affidavit in opposition,
Lordship,
list on date that deliver immediately on the reopening.
Lordship.
Obliged, my lord.
Item 14.
Maybe. Oh, good. Admission for admission for
Admission पुरानी was this one.
You file some affidavit also. Well, 2019, Madam Burma,
Already
the affidavit is ready.
Already filed.
Already filed, but my file is not available.
Mhm.
That was, I think. Okay. Long time back, Lordship, that was
Must be in 2019.
that was for the NRC purpose, Lordship.
Why so many affidavit, additional affidavit in opposition?
Yes, my lord, subsequently, my lord, her name appeared in the, my lord, NRC, final NRC. So additional affidavit has been filed. Bringing on
We
this.
are not examining NRC.
Yes,
If NRC contains the name, doesn't mean the person is a citizen.
yes.
If NRC does not contain a name, that also doesn't mean the person is
Yes,
not
right.
a citizen.
That is the subsequent, my lord, development, so it was,
So now, Sobita Begum,
yes.
you
Now, lordship,
discharge
kindly
your
see,
burden.
page 16 is the, my lord, grandparents' name.
16 grandparents.
Page 16.
Intaz Ali.
Intaz Ali.
He is
And my
the
lord,
grandfather.
yes, Shukron, grandmother.
Grandfather, Sukuran, grandmother, 1906, what is this? 66.
66.
Gaon,
Gao, my lord,
Mogi San or
Pug
something.
Jogijan.
Zogijan, Pug Jogijan.
Then, my lord, page, my lord, 18, lordship will find,
18, yes.
yes, her grandparents and my lord, father.
Sukur.
Shukur.
Sukur is the father, 1970. Gaon, Pug Jogijan.
Jogijan.
Now,
Yes.
which document will show Sukur is the father?
My lord, next page, my lord, page 14. Sorry, my lord, page 20. 20, my lord.
Sukurjan died in the meantime.
Yes.
Hmm?
My lord, my lord,
Mr. Mondal.
my lord.
Sukurjan died.
Shukurjan died.
Ah.
Then, my lord, Mina Begum,
Just a minute.
mother.
Slow, go a little slow. Sukurjan died.
Well.
In which year?
Lord, I have been told, my lord, in the year I have to, my lord, check, my lord.
Sorry.
I have to check, my lord, but I have
I
been
know.
told, my lord.
Because there is so much of a close proximity of the name of the mother Sukurjan and the name of the son Sukur. From Sukurjan, remove the part Jan, the resultant name is Sukur, and that Sukur is claimed to be the son now.
Yes. Now, page 20, lordship will find subsequently, my lord, name, my lord, Abdul Shukur. And
So
Shukur Ali.
now again he becomes Abdul Sukur.
Yes, Shukur Ali.
How
Yes,
these transformations take place?
Yes.
In what manner these transformations keep on taking place?
That is, my lord,
Because I think you are Mr. M.U. Mondal right from your birth, I believe.
yes,
From the day you can remember of your own life, you are M.U. Mondal only, nothing else.
yes, that is,
You did not transform
that-
from one stage to another stage.
yes.
Then why are these people being transformed?
Now, this is, my lord, my humble submission, my lord, because of illiteracy rates. My
Sorry,
lord, the illiteracy rates.
illiterate.
Yes, those people are, my lord,
So
below
these
poverty line.
people are illiterate, so therefore
As
they
well-
keep on transforming
Yes.
their identity
Malad,
from one to the other.
Yes, illiterate as
And
well as
if you are
below poverty line.
literate, you don't transform.
My lord, illiterate as well as below poverty line. So they are not concerned with the, my lord, correct name, as we have seen in the,
So therefore, we have to believe you now that Sukurjan died between 1966 and 70. And in place of Sukurjan, there appears the name of her son Sukur. So we are required to accept that.
my lord, that is the, my lord, records, my lord, we cannot speak beyond the records, my lord.
But the records may be of somebody else, not of yours. That is a possibility. Records speak, no doubt, but this record may pertain to some other person, may not be to this person. How do you know that it pertains to this
But
person?
the my lord, impugn order opinion that does not say so.
So you are satisfied with the impugn order. Then you withdraw the writ petition. If the impugn order is right, you withdraw the writ petition.
Impugn order say we have failed to establish the linkage between the.
So if you're so happy with the interim order, close it on. We close the writ petition.
We are not happy because of that we have approached.
So then why are you relying on an unhappy order then to again establish your right? Can you do it?
Now, page 20, my lord, so my lord,
The superintendent of police border of
Nagaon Lodge.
Nagaon district to make a thorough inquiry and submit a report before the court. Whether report as to when Sukuran, wife of Intaz, whose name appears in the voters list of 1966, died. In a situation where it is claimed that she died between the year 1966 and 1970. As a result, the 1970 voters list contains the name of Sukur, who is claimed to be the son of Intaz. The verification be made specifically whether Sukuran of the 1966 voters list and Sukur of the 1970 voters list are mother and son, or they are in fact, they are the same person, that is the mother herself, that is Sukuran herself. Report be submitted on the next returnable date. Copy of the order we will give.
Item 15.
The superintendent of police to also verify whether the name of Sukur did appear in any prior voters list, any voters list prior to 1970, along with Sukuran.
Lordship, Zabed Ali is the father of the petitioner.
Page number.
Lordship, page number 33, Annex 10. A Gabura certificate has issued by the Gabura of Hardia Pump.
What does he certify?
Halima Khatun, the petitioner, daughter of late Zabed Ali, village Hardia Pump, Moja, Pasim Bangkor under Hazur Revenue Circle. I know that their name have been found in the voter list of 1970.
The Sarkari Gambura of which village?
Hardia Pump.
Of Hardia Pump to file an affidavit before the court, namely Bharat Chandra Kolita, to file an affidavit. What is the special means of his knowledge to certify that? That Halima Khatun is the daughter of Javed Ali of Hardia Pump village.
Lordship, there is another Gabura certificate. The petitioner's father shifted to village Phelkar, and the Gabura of the Phelkar also issued this Gabura certificate, which is page number 47, Annex 14.
A similar certificate affidavit be also filed by who is he? Bokor.
Pakar Ali, DW3.
By DW3 Bokar Ali, who had deposed who also claims to be a Gambura of
Village Bhelkar,
Felkar.
or village number 1 Bhelkar.
number 1 Bhelkar.
Felkar.
A copy of the order. I think you can take.
Lordship, in his cross, he says, Proceedi was born before I became Gangura.
No, that's why let him say special knowledge. But that is section 50.
Lordship, but in Annex 13, where the Gavura also admitted that the petitioner born and brought up was there in that village. The first Gavura, that is the DW2 Bharat Chandra Kolita Gavura Hardia Pam.
Suppose Madam Verma gets hold of a Gambura and makes a deposition before anyone that this Halima Khatun is a thief. Will she become a thief? If she cannot become a thief, how can she become the daughter of so and so by the same certificate? To become the daughter, certificate is acceptable, but to be called a thief, it is not be acceptable. Why two different standards?
Let's see.
It will give a copy to MSU does.
I think, my lord, but my lord, police can, my lord, give a call and then he can come. But we will have to call him through the deputy commissioner. my lord.
Madam Verma will be more influential. A copy of the order will be provided to both Madam A. Verma and MS Mission.
Fine, obliged.
We'll coordinate, Lordship. After vacation, Lordships.
Item 16.
May please, your lordship, the fathers.
The Home Department to also examine as to whether the certificate issued by the two Gamburas and their deposition, comma, if available, do satisfy the requirement of section 50 of the Evidence Act in the earlier matter. Yes, Mr.
Lordship, page 40 and 41, lordship. 66 total list. Barnacular is 41. Madhumia's father, Javed Nasa is mother. Rasulpur.
Sorry,
Madhumia is father,
Ainul Haq is the
party lordship, petitioner.
party. And Madhumia is the father.
Father, Javed Nasa is mother. Lordship, case lordship 30.
Again, Gambura.
Same village lordship, Rasulpur. Madhumia's father, Javed Nasa mother, and Ainul Hussain lordship.
How do you know that Madhumia is a citizen?
Father lordship.
How do you know he is a citizen?
66 voter list lordship.
Page number.
40 lordship. Madhumia and Javed Nasa. Barnacular page 41 lordship.
Rasulpur.
Rasulpur. 89.
And 97 is of village Rangapani.
1989 lordship, the Rasulpur. Petitioner name along with the parents.
89.
89.
Which page?
Page 30.
So now to whom notice is issued?
To the Ainal Haq.
Aina?
Ainal Haq.
Haq.
My name is Ainal Hussain.
Ah,
Notice issued Ainal Haq,
Ainal Haq of which village?
the Rangabani.
Rangapani village. So you are claiming that you are Ainal Hussain of the
Ainal Hussain.
Ainal Hussain of Rasulpur village.
Rasulpur.
How you prove it?
Later on shifted due to erosion of the big.
While shifting, the name also changed.
The Rangabani.
No, while shifting, the name also changed.
Yes, yes. Rangabani shifted from the Rasulpur to Rangabani. Near
Understand
village,
that.
near village.
If we had shifted, at least the name of the person should have been same. How along with shifting, the name of the person also got changed?
The title is the different. The father name is same, Modumia, and notice was issued Ainal Haq. But my name is Ainal Hussain.
In case he's Ainal Hussain, why has he submitted the Gaupura certificate of Ainal Haq then? At page 27, Lordship. He has exhibited a certificate from the Gaupura. This is to certify that Ainal Haq. That means Ainal Haq and Ainal Hussain, they're one and the same person.
Ainal Haq of Rangapani is there.
Yes, sir.
So he is the proceedee.
Yes,
Now he claims that he is Ainal Hussain of
of the other village.
of that
Rasulpur.
what is called Rasulpur.
Rasulpur, Lordship.
The petitioner may produce any relevant material which may show that Ainal Haq of Rangapani and Ainal Hussain of the voters list of 1985 of village Rasulpur are one and the same person.
File additional evidence. Plus.
17.
Yes, please, your lordship. My lord, my grandfather's name in 1966, my lord.
Nosia Khotun.
Yes, my lord.
Now, who
My
is the grandfather? Page number
My lord, page 13, my lord.
13.
Total is 1966.
13 Modhu Holmari.
My lord,
Good
next
report.
14, my lord.
And Tepu Sheikh is
Tepu
the
Sheikh, my lord, grandfather.
grandfather. Now, who is the
And-
father?
Bodron Bibi is grandmother, my lord.
Now, who is the
Now,
father?
my lord, father, my lord. Page 25, my lord. Nasatullah Sheikh Tepu.
Is this that of the same village?
My lord, only thing is that my grandfather was in village Modhusulmari Part 2, and after the death of my grandfather, my lord, my father shifted to TMRE Part 2 and the same police station, just my lord distance only PW Road, my lord, just old High Court building and new High Court building, just like my lord. The western
So
side.
can the new High Court building ever become the old High Court building?
My lord, the road, my lord, only
No,
road.
no,
difference.
if I accept your explanation, then the new High Court building can also be said to be the old High Court building
No, my lord.
because it is only across the road.
No, my lord. The only PW I have stated in para 5. Only PW road is in the middle boundary.
Okay, this is also a PW road, I think. This is. Or
The
it's some-
western side is the Modhusulmari.
So if it is PWD road, it is same person.
No, my lord.
If it is a different road called MG road, it cannot be.
Modhusulmari Part 2 and now TMRE Part 2. In the before 1980s, earlier there Modhusulmari.
Mr. Counsel, are you aware that stories cannot substitute evidence?
My lord. But the name
But
is
produce the evidence, not the
Yes, my lord.
stories.
same. My lord.
Sorry.
And thereafter, my lord,
Mr. Counsel, why you are skipping the question?
my lord.
Can stories
No, my lord, that it is,
take place of evidence?
my lord, it is in the evidence of the petitioner that my grandfather's,
Evidence of the petitioner.
my lord.
So suppose today you go and give evidence that you are Mukesh Ambani. Will you become Mukesh Ambani?
No, that.
You cannot.
But I have to. state-
Why? You can also go and say before anybody that I am so and so.
My lord,
Will you become that person?
I am sorry to say, my lord, suppose I have come from Dhubri, now I am Guwahati, my lord.
Sorry.
I have come from, I belong from Dhubri, my lord. Now I am at Guwahati, so I have mass tested, my permanent residence is Dhubri, my lord.
So, very well. So that is your statement. Is it converted to a evidence? You are from Dhubri, now in Guwahati, is your statement. Has
Yes.
it become your evidence? What is the difference between evidence and your
Yes, sir.
statement?
So whatever, thereafter, my lord,
No, don't go to thereafter. First, you clear what point you are arguing. Then you go to the next point.
name is same, my lord. Name is.
How many times you repeat the same questions day in, day out, again and again? Is there only one person of the same name in this world?
That should come in the,
Can you provide material that there is only one person bearing the name Tepu Sheikh in this world and no one else?
that is not.
You cannot. Then how can you say that they are not two different people? The petitioner claims that Tepu Sheikh of the 1970 voters list of village Mudhusolmari is also the Tepu, father of Nastullah Sheikh, of the 1979 voters list of village Tiamari Part 2. By stating that Tepu Sheikh of Mudhusolmari had later on shifted to village Tiamari. It is also stated that the two villages are divided by a PWD road, and therefore it is to be construed that they are one and the same village.
No, my lord, no, not same village like
Then
that. No. Not same village, my lord, that village separate village.
separate.
Village
Yes,
separate.
it really you are
My lord,
separate.
how can you say that?
And therefore,
I-
no further evidence is required to show that the Tipu Sheikh of Mudhusolmari and Tipu Sheikh of Tiamari are one and the same person. The Land Council for Petitioner may substantiate through any proposition of law which may show that no further evidence is required, except for the statement. What will you do? Read the evidence and find out. There are some answers there.
I have to collect that document.
Sorry,
I have to collect that documents, otherwise,
you have to collect the Evidence Act. So till now today, you had not gone through the Evidence Act.
no, my lord, I have, no, my lord. But if any documents is for
So this is
shifting,
a matter of evidence only.
Yes.
See which provision
Now,
of the
my lord,
Evidence Act will be applicable
now
and you prove your case that way.
question before us, whether shifting is, my lord, only problem is shifting, my lord. That is the,
Okay.
but
কি লিখিলো? And then here nagalagay show that Tipu Sheikh of Omuk village and Tipu Sheikh are the same person. Next,
18.
when do you want?
after vacation.
After vacation. Eighteen.
My lord, I am Sunabhanu. My father's name is Sohrab Ali, page 15. That is voter list of 66.
Sohrab Ali.
Yes,
He is the father.
he is my father.
Very well. Now, Simul Bari. Which material will show that Soravali is the father.
That lordship begins page 33. Operative portion, page 34. This is the land document where my name is there with my father.
Okay, let it go back. Heard Mr. M. U. Mahmood and counsel for the petitioner also heard that. The petitioner Sona Bhanu had been referred to the foreigners tribunal number. Where is the order?
68.
68,
Sorry, well, 78.
78 had been referred to the foreigners tribunal number 4 Gwalpara for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number FT bracket G4 743/16. Tribunal rendered an opinion dated 31/2018 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted in the writ proceeding. Reliance is placed on the voters list of 1966 of village Shimulbari, police station Lokhipur in the Gwalpara district, which contains the name of Soravali, son of late Ala Boxo at serial 357, and that of Sevaran Nessa, wife of Soravali at 358, where both are residing in the same house number 96. It is claimed that Soravali is the father and Sevaran Nessa is the mother. To substantiate that Soravali is the father, reliance is placed on a Jamabandi of a plot of land of village Shimulbari, which contains the information that the land in respect of Pata number 368 stood mutated, amongst others, in the name of Sona Bhanu, daughter of late Soravali, in place of Soravali, son of late Alabox. If the information contained in the Jamabandi is correct and acceptable, the petitioner may have discharged the burden under section 9 that she, being the daughter of Soravali of the 1966 voters list, is not a foreigner. In view of the above, remanded back to the tribunal to examine the voter 1966 of village Shimulbari, as well as the Jamabandi of the
Same village.
plot of land at village Shimulbari, and pass a reason order. The petitioner may also produce the order of the circle officer by which the mutation had been effected for examination of the tribunal. Respondents in the Home Department may verify and submit a report, more particularly whether Sona Bhanu, the petitioner, and Sona Bhanu of the Jamabandi referred above are one and the same person. Someone doing the needful, reason order be passed.
19,
Please, Your Lordship. My lord, here in this case, my lord, the petitioner's grandparent is voter at 1960 voter list, 61 voter list. Lordship will find at page 35. Hussain Ali Sheikh is the grandfather.
Sorry, page number
Page 35.
35.
36 the vernacular. Hussain Ali is the grandfather. My lord. Huh? Grandfather.
Sorry, which page number?
My lord, page 35.
35.
Hussain Ali Sheikh is the grandfather. Sinas Nessa is the
35 is 1966.
61 my lord.
Sorry, 61 village Tapar Bhita Gol, Thana Lokhipur.
Then my lord,
Hussain Ali Sheikh. Who is he? Hussain Ali?
my lord, Hussain Ali the grandfather.
Grandfather. And now who is the father?
Father, my lord, at 70 voter list, page 37. My lord, names are at page 38. Samsul Ali here recorded.
Samsul Ali is the father.
Father, Hussain Ali.
Hussain Ali, same village, Tapar Bhita.
Tapar Bhita.
And now who is the petitioner?
My lord,
Abdul Razak.
my lord.
Which document will show Abdul Razak?
My lord, at voter list of 1994, page 43. 11th part is at page 44. Abdul Razak is the petitioner, Samsul Haq, my lord, father, son of Hussein. A little variation of
Acha,
father's
they're
name,
together.
my lord.
Uh,
Page 43, the subsequent brutalist, my lord, 85
Let's
brutalist
go back.
also there.
Log, heard Messiah signal and counsel petitioner also heard. The petitioner who Abdul Razak had been referred to the foreigners tribunal number. Where is that order?
My lord, at page
80 something.
page 87.
Yeah, have been referred to the foreigners tribunal number 3, Kamrup Rural. Kamrup, for rendering an opinion as to whether he's a foreigner under the Foreigners Act 1946, resulting in registration of AFT bracket R 1149/2017, and opinion dated 8/10/2018 had been rendered declaring the petitioner to be a foreigner. Being aggrieved, district petition is instituted in the writ proceeding. Reliance is placed on a voters list of 1961 of village Taparvita, which contains the name of Hossein Ali Sheikh, son of Bassa, at serial 38, and that of Saina Nessa, wife of Hossein Ali, at 39. It is claimed that Hossein Ali is the grandfather and Saina Nessa is the grandmother of the petitioner, where both are residing in the same house number 18. Further reliance is placed on the voters list of 1970 of village Taparvita. Both of them died.
My lord,
Mother, father both died.
my father was examined.
No, grandfather and grandmother both
Grandmother
died.
died. They have died, my lord.
Which contain name of Samsul Ali, son of Hossein Ali, at serial 21. It is claimed that Samsul Ali is the father of the petitioner. Further reference is made to the voters list of 1994 of village Taparvita, which contains the name of Abdul Razak, son of Samsul, at serial 337, and that of Samsul Haq, son of Hussein, at 338, where both are residing in the same house number 146. It is taken note that Samsul Haq in 1994 was 48 years and Abdul Razak was 20 years, and therefore there could not have been any possibility of the name of Abdul Razak appearing in the voters list prior to 1994. In view of the above, reverted back to examine the voters list of 66, 70, and 1994 of the voter of village Taparvita and pass a reasoned order. Petitioner to produce the complete voters list of village Taparvita from the years 1961 to 1994 for examination of the tribunal. Respondents to make a verification submit report, as well as to verify whether the petitioner Abdul Razak and the Abdul Razak of the 1994 voters list of village Taparvita are one of the same person. Doing the need to reason order be passed.
20.
Rahman
Lord-
Khan.
Rahman Khan, but notice issued as Rahmat Ali.
Then how will you prove yourself?
My lord, record is also in both here, my lord. My lord, he, according to he,
Record is both ways more dangerous.
my
If
lord,
record is one way, then we understand.
my lord, kindly have a look at my lord, 66 voter list,
Page number
page 42,
42.
42. Monu Khan is the grandfather, Aimona grandmother, father's name Farman Khan. Others are paternal aunt and paternal uncles.
42, Monu Khan is the grandfather
Grandfather,
and Aimona Khan is the grandmother.
grandmother. Farman Khan is the father.
Farman Khan is the father. 1966.
My lord,
Village
yes.
is
Horipur.
Horipur. Okay. Now, which document will show that Rahman Khan is the son of Farman Khan?
My lord. In voter list of 1997. My lord,
Page number
70 voter list also required to be verified, my lord. Here, my lord, in 70 voter list, mother also voter. with parents, with father, my lord. 70 voter list.
Okay, and
Then-
after that, where is the 97?
1997 at page 46,
46. That vernacular is in 47.
my lord.
Serial number,
507 Rahmat Khan.
who is Rahmat Khan?
Mal is the proceeding, my lord.
He's Rahmat Khan or Rahman Khan?
My lord. My
Rahman
lord,
Khan.
his statement is that his actual name is Rahman Khan, but in 97 voter list, his name is wrongly written as Rahmat Khan. And that has been corrected subsequently. Lordship will find in the voter list of 2010, page 48,
It is made Rahman.
Rahman Khan. And
Actually, he's Rahman.
Rahman Khan. That is his statement
That
in the
is okay.
WS.
No,
Then
if
my
the
lord-
later one is there, it is okay.
My lord.
Village
Mother's,
is,
village is same, mother's name is also there, my lord.
what is the village?
Horipur.
Horipur. And 1970,
Mother's name is there, Romana
along with father Romena.
Khan.
And what happened to Romena is there?
Romana, my lord, in
No, Romena is there.
his name is there in 97, in
70, Romena
2010
is there.
also. Is 2010 also.
Acha, Romena is still alive.
Yes, my lord. And Romana was examined also, my lord.
Romena exam.
So, my lord, it's a clear case of my lord.
Yes.
Citizen, my lord. All along in voter in
70, Lordship 97 after
90.
70,
After 70 in between is not there.
in between, it's jumps
Let
to
him produce-
97,
let
and
him produce.
97 to 2000, that is okay, to 2010. But this in between,
No, let him produce all of it.
yes,
my
all
lord,
the voters
my lord,
list and continuous
89
stay,
voter list
Lordship.
also we have annexed, my lord. 89 voter list showing father's name and mother's name
So,
at page 66, my lord.
if 89 fathers and mothers' name is there, then how come in 97 father, where did
No,
the
no,
father-
97 father is not surviving,
Father died possibly.
died. Only mother.
Because Farman Khan is 22 in 66.
My lord,
So he must have been around 50 odd in 97.
my lord, my lord, he is voter in 89, my lord. I have 18, annexed the 89 voter list.
2016 is there, 2010, 16, but this big jump from 70 to 97.
That he'll produce complete.
Yes, let him produce all the in-between voters. list.
My lord,
Heard Mr. A.S. Iqbal and counsel of petitioner also. The petitioner Rahman Khan had been referred to the Foreigners Tribunal number 7 Borpeta for rendering opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of FP case number 43/2017. The tribunal rendered an opinion dated 59/2018 declaring the petitioner to be a foreigner, being aggrieved the said petition is instituted in the writ proceeding. Reliance is placed on the voters list of 1966 of village Horipur police station, Tarabari in the Borpeta district, which contains the name of Manu Khan, son of Arman at serial 88, and that of Farman Khan, son of Manu at serial 93. The voters list of 1970 of village Horipur contains the name of Manu Khan at serial 117, along with Farman Khan, son of Manu at 122, and Ramena Khatun, wife of Farman at serial 124. It is stated that Farman Khan is the father of the petitioner, Ramena Khatun is the mother, and Manu Khan is the grandfather. Thereafter, reliance is placed on the voters list of 1997 of village Horipur, which contains the name of Rahmat Khan, son of Farman at serial 507, and Ramena Khatun, wife of Farman at 509. The voters list of 1989 of village Horipur contained the name of Farman Khan and Ramena Khatun together. The later voters list of 2000. Where is the Rahman Khan come? 2010.
2010 at page 48.
10 of the village Haripur had corrected the name of Rahmat Khan as Rahmat Khan. And it is thought to be explained that Rahmat Khan was an aberration in the voters list of 1997, whereas the petitioner is Rahman Khan. MSC Vermal and counsel for the Home Department raises the objection that there is no in-between voters list from 1970 to
97.
97. although a reference is made by Mr. Sigda to a voters list of 1989.
Nine.
We were remand back to examine the voters list of 1966, 1970, 19 and 1989 and 1997. And thereafter pass 1997. The tribunal to examine the voters list also. And so the petitioner to produce a complete voters list from year 1996 to 1997 of village Horipur, as well as the later voters list of 2010, etc.
77 also, Lordship.
Or continuous.
Yes. Lord.
Complete and continuous voters list from of all the years from 66 to 97. Respondents in the Home Department to make a verification submit report. The report to also contain whether Rahmat Khan and Rahman Khan are the same person and whether the Rahman Khan of the 2010 voters list and the writ petitioner Rahman Khan are the one and the same person. When doing the needful,
Copy
Leave
of this order may
copy
be
of the
given.
order.
Develop.
আমি একটু পাতলা রইলে এটা নাই আমার ভাই
Yes.
Your lordship, report was torn.
Hmm. Yes, what your report says? Hmm.
I have submitted the report, lordship.
Is the father. This Maiful is the daughter of so and so.
Yes.
Well, let it go back.
Yes.
Heard you, Bormon.
R. Chetri.
Huh?
R. Chetri.
R. Chetri. Heard Mr. R. Chetri and also. The counsel for the petitioner also heard. My full Nessa had been referred to the foreigners tribunal number. One Borpeta for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT case number 219/2016. Tribunal rendered an opinion dated 29/11/2018 declaring the petitioner to be a foreigner. Being aggrieved, a state petition is instituted in the writ proceeding. Which voters list you are relying?
66,
Page number.
page number 11.
Relies upon the voters list of 1966 of village Boniarpara police station, Borpeta, in the Borpeta district, present Borpeta district, which contains the name of Gopal Sheikh,
Gopal Singh.
son of Kosai Sheikh. No, not Kosai. What is it? Kukai.
Kukai.
Kukai Sheikh at serial 337. And it is claimed that Gopal Sheikh is the father of the petitioner. In course of the hearing, the petitioner could not produce any relevant material which may show that Gopal Sheikh of the 1966 voters list is the father of the petitioner. But however, on the other hand, it is noticed that if the petitioner can establish that she is the daughter of Gopal Sheikh, perhaps the burden under Section 9 of the Foreigners Act 1946 had been discharged. In the circumstance, we require, by our order of 29/5/2023, we required the Superintendent of Police Borpeta to make a verification and submit a report before the court as to whether the petitioner Maiful Nessa is the daughter of Gopal Sheikh of the 1966 voters list of village Boniarpara. A report dated 7/6/2023 had been produced before the court, which states that Gopal Sheikh, son of Kusai of the 1970 voters list of village Boniarpara, Kamrup, is, presently in the Borpeta district, is the father of the petitioner. As the verification report of the Subarnapur Police Border shows that the petitioner Maiful Nessa is the daughter of Gopal Sheikh of the 1970 voters list of village Boniarpara. We remand the matter back to the tribunal to examine the aspect and pass a reasoned order. The report submitted by the Superintendent of Police be made also available before the tribunal for its examination by the Home Department of the Government of Assam. Accordingly, the report produced before the court is returned back to Mr. G. Sharma and counsel for the Home Department to enable it to be presented before the tribunal. Respondents may make any further verification if so advised and submit report upon the during the needful reason order be passed. Further, the Jamabandi in respect of a plot of land at village Salekura. Salekura no shows that Maiful Nessa had inherited the land of Gopal Sheikh, but the land is located at a different village, at village Salekura, which apparently is different from village Boniarpara of the voters list of 1970. Tribunal may also examine the aforesaid aspects. Permission দিব reasoned order. এর উপরে দিয়ে দিব এখানে।
Item 22.
Yes, Vigilance. Well, in this case also, instruction was sought for regarding the inquiry to be made by the Superintendent of Police Border.
What a report. What does it say? Same person. Let it go back then. Heard Mr. M. Khan, no? And then counsel for the petitioner. Is the SP actually making inquiry or what is the basis of these reports? Because the only one line is written there. No, understand. Is the SP actually making a report or he is? Does he verify anything? Because reports may be of two kinds.
Yes, Lordship. Only basis
One
of-
may be a report depicting the existence of something, another may be a report on being created.
Yes, Lord.
What kind of reports are these? So why you are asking this question? In almost every matter where we are asked the SP to file a report, the question is always answered in the affirmative.
Yes.
Till now, the report of the SP has not come, which has taken a contrary view.
Yes, Lordship. In some of the cases, not saying contrary view is taken, but there, those cases are not listed out.
Not listed.
Yes,
Make a mention.
yes, sir. Yes, yes,
Give a mention. Not listing is not an issue at all.
yes, sir. Yes, sir.
You have to just make a list, give it to us. We'll get it listed. Because there may be a procedure in place
Yes,
where the matter should not be listed, may not be listed.
yes, sir.
The petitioner Rashidul Islam had been referred to the Foreigners Tribunal number 2, Kamrup Metro at Guwahati for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946. Tribunal rendered an opinion dated 37/2018 declaring the petitioner to be a foreigner, being agreed the said petition is instituted in the writ proceeding. The petitioner refers to the voters list of 1970 of village Kukurmara Part 2, which contains the name of Kalachand Sheikh, son of Abdul at serial 260, and that of Javeda Khatun Bibi, wife of Kalachand at serial 261, where both are residents of house number 78. In the voters list of 1977, the voters list of 1977 contains the name of Kalachand Sheikh, son of Abdul Diwani, at serial 332, Javeda Khatun, wife of Kalachand, at serial 333. The voters list of 1989 of village Kukurmara Part 2 contains the name of Kalachand, son of Abdul, at serial 57, Javeda Khatun, wife of Kalachand, at serial 58, and that of Nazrul Haq, son of Kalachand, at serial 59. The voters list of 2005 of village Kukurmara contains the name of Nazrul Islam, son of Kalachand, at serial 894, and Joshena Khatun, wife of Nazrul Islam, at 895. Whereas the voters list of 2016 of village Kukurmara Part 2 contains the name of Rashidul Islam, son of Nazrul, at serial 560, and that of Akitara Begum, wife or daughter, Akitara?
But actually, she's the wife of Sohizal Haq, but wrongly given the father-in-law's name.
Daughter.
Matlab, Akitara, wife of,
Akitara is the wife or daughter of Nazrul?
so my lord, daughter-in-law of Nazrul. Wife
The
of
name of Akitara, who is stated to be the daughter-in-law of Nazrul Haq. By an order of 31/3/2023, a report was called from the Deputy Commissioner of Police, Border, Kamrup Metro, upon conducting an inquiry as to whether Nazrul Haq, son of Kalachand, in the 1989 voters list of village Kukurubara Part 2, and Nazrul Islam, son of Kalachand, in the voters list of 2005 and 16 are one and the same person. A report dated 10/5/2023 of the Superintendent of the Deputy Superintendent of Police, Border, Kamrup Metro had been produced before the court, which shows that Nazrul Haq and Nazrul Islam are one and the same person. In view of the matter, remanded back to the tribunal to examine the voters list of 1970, 1977, 1989, 1997, 2005, and 2016 of village Kukurmara Part 2, and thereafter, thereupon pass a reasoned order.
My lord, the report, DSP lordship, Kamrup or Sasan. That we will-
Kamrup.
because of the person.
No, our order was Kamrup. Deputy Commissioner Police, Kamrup Metro.
The person from Sasan.
And this is Superintendent Police Border, Simantapur, Guwahati, Kamrup. The copy of the report is returned back to Mr. G. Sharma for it to be produced before the tribunal. Tribunal for its examination.
Yeah, we will launch it. My lord, here I need some time because there is shifting from one village to another.
MSD Ghosh, Rank Council Petitioner, seeks for some further time to do the needful as indicated in the order of 14/6/2023.
24.
Lordship, on the last occasion, the superintendent of police was directed to appear personally. And this honorable court had desired to circulate some points to all the SP's border, which was duly submitted to the Inspector General of Police.
Just a minute, pursuant to already ordered, the SP is personally present. But in our earlier interaction with the Superintendent of Police Border Kachar on 23/5/2023, it was expressed that the deliberations that took place on the said date with the Superintendent of Police be also circulated and made available to all other superintendents of police border of the various districts. Accordingly, the Superintendent of Police Border Kachar had made a communication dated 3/6/2023 to the Inspector General of Police Border Assam. The Inspector General of Police Border Assam is directed to circulate the same amongst all the superintendents of police.
Lordship, the report is on the next loose sheet, Lordship, dated 26/23. The submission of status report of Borkhola PS case number.
That is other one. Status report of Borkhola be provided. By the same order, the status of 23/5/2023, the status report of Borkhola Police Station case was 65/2023 was also required to be provided. The report provided 2026/2020 indicates that the case is pending for further investigation and efforts are made to complete the investigation. Full stop. As it is understood that the matter is already under investigation, therefore the updated status report as required earlier be produced before the court.
Lordship, the matter will be fixed after vacation.
Less on 1st August. Lordship. The two communications from the Superintendent of Police are kept on record.
Lordship petitioner, given some protection so that she can also cooperate with the Lordship.
See, we have ordered a police case, means something must be there. Let the report come.
Because of lordship.
Protection, the police will give you the necessary protection.
Lordship, she is not in interim lordship, so I think.
The police will give you the necessary protection, whatever is required.
Well,
See, moment we have ordered a police case, that means something prima facie was noticed. Possibly some manipulated material. If that was noticed, how do you expect that some interim order in your favor will be passed? Will it not be self-conflicting?
lordship, it is true,
Let the
lordship.
report come.
Well,
25.
Nazrul Hussain,
His lordship 32 lordship,
page
One.
32.
66 voter list.
Who is the father? Muzammil,
Muzammil Hussain is the grandfather.
grandfather.
Dodnehar Bibi is the
Dulne Bibi is the
Grandmother.
grandmother. This is of 1966. Village is Kahibari Farm. Moza Mandia, Barpeta. Now, which
70
the-
70 also same lordship.
Who is the father?
Father lordship page 36 and 37 lordship.
Muzammil is the
Grandfather,
grandfather
Dodnehar is the grandmother, and Nobi Hussain
and Nobi is the father.
father lordship. He is the DW2 lordship.
Father. Kahibari Farm. Okay.
Kahibari Farm.
So now, who is the petitioner?
Nazrul
Which
Hussain.
document will show Nazrul is
The father is DW2. Divorced before the tribunal. lordship.
Nobi as DW2. That's the only evidence.
The lordship, and the 2017 is the lordship voter list 49 lordship. Yes. 49, 48. lordship.
What is the age of Nazrul?
Nazrul 31 lordship.
At present 31.
30.
Okay. Now which page?
This lordship
Voter list
49, 50 lordship.
49.
49. Kahibari Farm lordship.
Same village.
Same village lordship. The Nobi Hussain lordship.
What do you do? Mr. Sharma? Mr. N. Namal and counsel for appellation. The petitioner Nazrul Hussain Khan had been referred to the Foreigners Tribunal number,
Two lordship, Kamrup Metro.
Foreigners Tribunal number 2, Kamrup Metro,
Case
for
77.
rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of case FT case number 354/2018. The tribunal rendered an opinion dated
10/10/2019. Page 77.
date, not page.
10/10/2019.
10/10/2019, declaring the petitioner to be a foreigner, being aggrieved, the state petition is instituted in the proceeding. The petitioner relies upon the voters list of 1966 of village Kahibari Farm, police station, Bagbor in the Borpeta district, which contains the name of Muzammil Hussain, son of Muhammad Hussain, at serial 165, and that of Dud Meher Bibi, wife of Muzammil, at serial 166, where both are residing at house number 55. It is claimed that Muzammil Hussain is the grandfather and Dud Meher is the grandmother of the petitioners. Similar information is available in the voters list of 1970. Full stop. The voters list of 1975 of village Kahibari Farm contains the name of Muzammil Hussain, son of Muhammad at serial 234, and that of Nabi Hussain, son of Muzammil at serial 236. It is claimed that Nabi Hussain is the father of the petitioner, and as his name appears along with Muzammil Hussain in the same voters list, it has been established that Nabi Hussain is a citizen. Reliance is placed on the voters list of 2017 of village Kahiberi Palm, which contains the name of Nabir Hussain Khan, son of Muzammil at 352, and Nazrul Hussain Khan, son of Nabir Hussain Khan at 356. Nazrul Hussain Khan is shown to be 25 years. It is claimed that Nazrul Hussain Khan of the 2017 voters list is the petitioner himself. It is noticed that in the earlier voters list up to 1975, the father is shown as Nabi Hussain, son of Muzammil, whereas in the voters year 2017, it is Nabir Hussain Khan, son of Muzammil. A question would remain as to whether Nabi Hussain and Nabir Hussain Khan are one and the same person. Further, the petitioner is Nazrul Hussain Khan, whereas in the voters list of 2017, it contains the name of Nazrul Hussain Khan. So another question would arise as to whether Nazrul Hussain and Nazrul Hussain Khan are one and the same person. A view of the above remanded back to the tribunal to examine the voters list of 1970, 75, and all other in between voters list up to 2017 of village Kahibari Palm, which the petitioner to produce before the tribunal. The respondents in the Home Department may make their verification as to whether Nabir Hussain Khan and Nazrul and Nabir Hussain Khan of 2017 voters list and Nabi Hussain of 75 voters list are the same person, as well as whether Nazrul Hussain Khan of the 17 voters list 2017 and Nazrul Hussain, the writ petitioner, are one and the same person. Upon doing the needful, report be submitted to the tribunal. Full stop. The tribunal shall examine as indicated above and pass a written order.
26.
Farida Khatun.
Yes. Father is Ahed Ali, page number 62, Lordship.
Ahed Ali, father.
Father,
Which document will show Ahed Ali?
father reduced evidence as DW2.
Cross-examined.
Yes, Lordship.
Yes, Mr. Sharma.
Cross party is on 46 and 47, and evidence is on 37 to 39. Cross part
Yes,
46.
send back, you cross-examine DW2 further. Yeah, if you want.
He was cross-examined 46.
Cross-examine in a more appropriate way.
Yes, sir.
Sometimes what you are doing will notice, if somebody could not prove his case, you put such a question in the cross-examination that the lacuna is also filled up. Because why we're saying this, cross-examination will be a very, very important instrument in the hands of the respondents. Because now we are going more towards section 50 of the Evidence Act. 50 of the Evidence Act says special means of having the knowledge. Whether the person has the special means or not, you can extract the veracity only by appropriate cross-examination, not otherwise, and not asking those casual questions. So maybe a time will come when you'll have to train up your government leaders. What is cross-examination, what is the purpose, and what is to be done? Otherwise, everything will be futile as before. Yes, so what do you say? Because the whole thing, the Evidence Act provides for section 50. And that will be precisely, it will be cross-examination based. So unless you cross-examine very scientifically and with due application of mind, the purpose of section 50 will not be achieved. Sorry,
We have to start with it, Lordship, now.
I think it's maybe it's a necessity also. Just call up one of those sessions and give them the. You all can address the session and give the inputs exactly what to do and.
There's no oath of us, sir. Why you do that? It's not cross, it's on oath. He has given evidence on affidavit and it was only the question but to the court. It's not,
Understand, it's not.
cross-examination was, yeah, the cross-examination was done of
Counsel for the
Gaungura
petitioner also.
and all other
The
headmaster.
petitioner
Lakpal.
Farida Khatun had been referred to the Foreigners Tribunal
Number 3,
number
Nagaon.
3, Noga,
Yes, Lordship.
for rendering an
Case
opinion
19.
as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of
Yes,
case
Lordship,
number,
FT case number 49 of the 2017
FT case number 49
of 2017.
of stroke 2017. Tribunal rendered an opinion dated
13/11/2020.
13/11/20 to declaring the petitioner to be a foreigner, being aggrieved this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Colony Zala, police station Rupohi in the Nagaon district, which contains the name of Ahed Ali, son of Sabar Ali at serial 300. It is Ahed Ali had deposed before the tribunal as DW2, stating that the petitioner Farida Khatun is his daughter. But it is noticed that DW2 had not been cross-examined by the respondents in the Home Department. In view of the above, matter remanded back to the tribunal to enable the Home Department to cross-examine DW2 in an appropriate manner, so as to extract the veracity of the evidence rendered by him upon doing the needful reason or review.
My lord. Now, if he, because he is above 80 now, if he is in a fragile state, then,
You have to preserve him.
and I have no instruction because.
But
still
if
they
he's in a
don't
fragile
have
state, what to do? You have to do.
any- Yes, might be. Then
Mhm.
commission has to. Because all other voters list and everything was there.
It is
From-
stated that DW2 may be around 80 years old as of now,
And I'm
and
not
his
sure.
physical state is not known to the Land Council for the petitioner. If necessity arises, the cross-examination of DW2 may be done through the method of appointing a commission, and the cost of which shall be borne by the petitioner.
Deputy.
27.
May please lordship, the petitioner is the Sahira Khatun. The page 23 lordship. And 24 Barnigula. Page 23 and 24. 24 is Barnigula.
Kandulia.
Tahir Ali,
Kandulia is the village.
Kandulia,
Kandulia is the village.
village.
Tahir Ali is the father.
Father, Laljan Nasa is mother.
Laljan mother. Which document will show Tahir is the father?
Lordship, the Jamabandi Gobi, page 46.
46.
Barnigula is 46.
Kandulia, same village.
Same village. The order 47.
Tahir Ali.
So,
And the petitioner is Sahira. Where is Sahira?
Chakra Bifayar, 4 April 2018 Tarikh, Namdari, number 7 Hukum Uttar Dige Putre, Tahir Ali Riskolot. Kandulia.
Sorry. If you can handle, no difficulty. Right? Put it. Third, Mr. N. Ahmed and counsel for petitioner also heard that. Sahira Khatun had been referred to the foreigners tribunal number. Where is it? Page number
58.
58 has been referred to the foreigners tribunal number.
Tribunal number 2 Bangaya.
Foreigners tribunal Bongaigaon, foreigners number 2 Bongaigaon at Ahoyapuri for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of case number BNGN/FT-2/APR/case number 79/16. Tribunal rendered an opinion dated 4/11/2016 declaring the petitioner to be a foreigner. In the writ proceeding, reliance is placed on the voters list of 1966 of village Kandulia, police station Bagbor in the Borpeta district, which contains the name of Tahir Ali, son of Muhammad Ali at serial 252, and Laljan Nisa, wife of Tahir Ali at serial 253, where both are residing in the same house number 82. It is claimed that Tahir Ali is the father and Laljan Nisa is the mother of the petitioner. To establish that the petitioner is the daughter of Tahir Ali, reliance is placed on the Jamabandi in respect of a plot of land at village Kandulia, which shows that the name of Sahira Khatun, daughter of Tahir Ali, amongst others, had been mutated in place of Tahir Ali, son of Muhammad Pramanik. So Muhammad Ali and Pramanik, same man.
Same lordship.
How do you know? How do you know they are same?
Same lordship, the Muhammad Ali and Muhammad Ali Pradhani. Sometime written Pradhani lordship.
Not Pradhani, Paramanik.
Paramani.
Pradhani is different.
Different.
He becomes a kind of a leader of that community and becomes Pradhani.
Lordship.
But Paramanik is not Pradhani.
No.
So how Ali and Paramanik, how do you say? A question would remain as to whether Muhammad Ali being the father of Tahir Ali in the 1966 voters list and Muhammad Pramanik being the father of Tahir Ali in the Jamabandi are one and the same person. The tribunal to examine the said aspect and arrive at a conclusion. Full stop. The order of the circle officer dated 18/11/2018 also shows that the land had been mutated in favor of Sahira Khatun in place of Tahir Ali. In respect of a plot of land of village Kandulia. few of the above remanded back to examine the voters list of 1966 of village Kandulia as well as the Jamabandi relied upon. And upon doing the needful, a reason order be passed. The respondents to make a verification and submit report as to whether Sahira Khatun, the petitioner, and Sahira Khatun referred in the Jamabandi are one and the same person. Nine. Are they one?
28.
Abdul Jalil.
Abdul Jalil, Abdul Jalil, Abdul Jalil Mia, and A Jalil.
Lordship, I have communicated, but.
You want some time?
Lordship.
Adjourn on the prayer of MSB Dekhal and of the Education Department to provide the needful as indicated in the order 13/6/2020 after vacation.
29.
As per the last order, Lordship, we were supposed to,
That is your writ petition.
yes, Lordship.
If that is the writ petition,
Yes, Lordship.
it can be prima facie understood that you don't have a very good case.
I have a very good.
So
case.
therefore you need documents of at least 200 pages to substantiate something.
Lordship, I have documents, genuine documents, and
Means he has so
Actually-
much of documents that it has crossed 200 pages.
yes, even father has adduced evidence, mother has adduced evidence, brother has adduced evidence, neighbor has adduced evidence. In this case, Lordship, father is there from 66.
There is a saying in Assamese. I think you know the saying.
Yes, Lordship. As far as the last.
Too much
order-
of everything is too bad also.
As per the last order, Lordship.
Last order, what is it? This a mutation.
Yes, or that order we
You
have.
got it?
Yes, Lordship.
Where is the mutation order? It will be.
We have applied. Application also is there, copy of the application.
Did you get the mutation order?
Yes, this is the thing which they have provided to us. An application also is there, Lordship.
Hmm.
We had applied. Online, we could not because of the OTP process.
Hmm.
So we have done it offline.
So now petitioner is Ayatan Nessa.
Yes, Lordship.
And who is the father?
Tara Mia.
Where is the name of Taramia?
Tara Mia Logot. Yatan Nessa Pitri Tara Mia Namot Namjari.
Taramia, your serial number 3. Peter Riaz.
Yes, Lordship.
Hmm.
Yeah,
And petitioner is Yatan Nessa,
yes, Lordship.
daughter of Taramia.
Taramia.
And where is the circle officer order? Page dated.
So this is the one which.
Hmm. Circle officer order date, mutation order.
Date of the order,
Hmm.
29/3/2019.
23,
29/3/2019.
2019.
Record Namjari. Hukum Morbe.
মাটি দান দখলৰ সূত্ৰে These are gift deeds.
Yes. He
These
has
are not
given-
inheritance.
Not in it, because he is alive. DW2,
So the gift was made to facilitate the tribunal proceeding.
he has gifted to his daughter.
Hmm.
He has gifted to his daughter.
And Taramia, where does his name appear?
It's 66 Lordship, page 312. It's
Page?
written as Tata Mia. He's Tara Mia.
Page number
Page number 312.
31. Page 31.
312. 312.
300 and, so it's not 200 pages, it's 300 pages.
Yes. You know, my colleague had worked hard in this case. She has prepared all the evidences before the learned tribunal, stating all the material facts.
Yes. Tata. And Tata is Tara,
Yes, Lordship.
village, Loruazan. And this
Village also is same,
is
Lordship.
also Loruazan. Will they take the order at 2?
Yes, Lordship.
It's okay, so very-
Item 29.
Yes. Hmm. What is it? What's your matter?
Yes, Lordship.
You can't expect me to retain everything for 100.
Yes, sorry, Lordship. Father name is Tara Mia. And Tara Mia,
Tarami and Tatamia.
yes, and
Which page?
page 312.
31312.
Yes, Lordship.
Okay. Tatamia and Taramia. And
And
he is the father. No?
yes, and Tara,
And this Jamabandi. Jamabandi Taramia and Yatan Nessa. Yatan Nessa is the petitioner.
yes, Lordship.
Heard MSD Ghosh and counsel for a petitioner also heard. The petitioner Ayatan Nessa had been referred to the Foreigners Tribunal number.
Kamrup Rural number 1.
Foreigners Tribunal.
Page 63, Lordship. Impugn order,
So the Foreigners Tribunal number 1, Kamrup
rural.
Rural. Resulting in registration of GFT bracket R case number 863/2017. Tribunal rendered an opinion dated 17/3/2022 declaring the petitioner to be a foreigner, being aggrieved with writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Larwazan, police station Soigao, Moza Pup Samoria in the Kamrup district, which contains the name of Riaz Uddin, son of Goser at serial 229, and that of Tasiran Nessa, wife of Riaz at serial 230, and Tatamia, son of Riaz at serial 231. It is stated that Riazuddin is the grandfather, Tasiran Nessa is the grandmother, and Tatamia is the father of the petitioner. It is also clarified that the name actually is Taramia and not Tatamia. Has it been corrected in some?
Yes, 77 voters list.
Which
316.
correction can be noticed in a voters list of 1977 of village Larwajan, where in at serial 263 appears the name of Taramia, son of Riazuddin. Further reliance is placed on a Jamabandi of a plot of land of village Larwajan, wherein the information contained is that name it is that land in the name of Taramia had also been mutated in favor of Yatannesa, daughter of Taramia, through a gifted. And there is an order of the circle officer dated 29/3/2019 in mutation case number KAM/2018/19/701/FMUT, by which, in respect of 10 less of land of DAG number 285, there is a mutation in favor of Yatannesa, daughter of Taramia, in place of Taramia. Accordingly, it is claimed that the burden under Section 9 of the Foreigners Act 1946 had been discharged by the petitioner to show that she is a citizen inasmuch as a land of Taramia had been mutated in her name, whereas the name of Taramia also appears in the voters list of 1966 and 1970 of village Larwajan. In view of the above, remanded back to the tribunal to examine the voters list of 1966. Remand back you don't want. But here, can we do it?
For continuous voters list also we have exhibited before the learned tribunal is there.
What do you say?
66, 70, 77 lordship.
What do you
Father
say?
has adduced evidence, 89 voters list.
Acha, father also.
Yes, lordship, father evidence is
What do
at
you say, Mr. Sharma?
155 to 170 lordship.
You convince him.
Because this is only third round of litigation. Yes, lordship. Yes, this is the third round of litigation. Pain and agony.
Yes, Mr. Sharma.
What do you say? Why don't you finish it here only? Sorry. No, why not here only? Why remand back? What will you do on being remanded? Remanded back is not on a regulation basis. If there is something more to be done, only then we'll remand back. Sorry. Well, sorry, a little louder. Can't hear you.
Lordship, in circle officer order, Lordship, this is a gift deed, Lordship. On what basis, Lordship, circle officer mutated the land in the name,
You know the answer. How can we know?
Lordship? I think.
But
Lordship,
do you disbelieve this, that there is no order of the circle officer?
I don't disbelieve lordship, but
Then
lordship,
Then no,
what
no.
what is the basis lordship?
basis anyway, you cannot do anything. Because the list in this court is not whether the circle officer had factually passed a mutation order or not. That is not our lookout. Our lookout is if there is a mutation order from the father to the daughter, whether it establishes the father-daughter relationship. This is only our concern. We cannot question the circle officer in any manner. But this is not a revenue appeal or something.
It is true lordship.
Mm.
Lordship, I remanded for further cross examination of father lordship.
Of whom?
Father lordship.
Already cross-examined. Neera Das was the guarded counsel for the same.
Mm.
And cross is also not here. Then they were cross-examined. Page 171.
This is the reason why we require production of this Jamabandi. Because otherwise you would have remanded at that stage only. Mm. Why we ask for the certified copy, a fresh one. This is the reason. I remember like this. When we do the exercise, why should it again go back? And tell us what the tribunal will do. It's nothing like that the meal is cooked and let the tribunal eat it. If some further cooking is to be done, then you send it back to the tribunal.
Yeah, that is.
Taramia. Full stop. DW, the Taramia had also deposed before the tribunal as DW2,
Two lordship.
wherein he had specifically stated that Yatanesa is his daughter. DW2 had been cross-examined by the state authorities, but could not be confronted in any manner to rebut the evidence rendered that Yatanesa is his daughter. Mr. G. Sharma and counsel for the Home Department states that the matter may be remanded back to the tribunal, and upon that submission, we raise a query as to what further would be achieved upon the matter being remanded back. No acceptable answer is available as to what further the tribunal would do on being remanded back, as the materials available on record are itself clear and explicit enough, where Taramia had established that he is a person who at the best can be said to be who cannot be said to be a foreigner. And his oral evidence upon being cross-examined also could not be rebutted in any manner. And secondly, it being corroborated by further evidence through the contents of the Jamabandi, which also contains an extract of the order of the circle officer dated so and so. We are of the view that the petitioner cannot be declared to be a foreigner in the aforesaid facts and circumstances. Accordingly, the petitioner Ayatan Nisa is declared to be English citizen and shall be entitled to all.
Reproved.
Item 30.
Total is ready to put it.
Hmm?
Total is.
Abdul Jalil.
May I please your lordship? Lordship, the SPB will be directed to examine the voter list from 1966 to 1997, lordship.
Yes.
I have the instruction. Can it be on Monday, Lord?
Adjourn on the prayer, Mr. G. Sharma, and on the part. We will stay down.
Tuesday.
First lordship.
Item 30. Item 31. Item 31.
Lordship, in this matter, shifting is there. I may allow to file an additional affidavit with
Your name?
D Hussain.
Mr. D. Hussain and the petitioner seeks for adjournment to bring in additional material which may prove that the petitioner Abdul Rashid or his family has shifted from village
Uttor Athiawari.
Uttar
Athiawari.
Athiabari to
Safa Kamar. Safa Kamar.
Safa
Kamar.
Kamar. Safa Kamar.
Obliged.
32.
Notice issued.
Lordship.
Yes.
Page 17, my lord, is the 66 Buddha list of father, my lord. Page 17, my lord. Next one. Page 18, serial number 384.
Digir Park,
Lordship.
66. Who is the father?
Page 18, my lord.
Name of the father?
348, my lord, Faizuddin, my lord. Here, my lord,
Faizuddin.
Faizuddin.
Faizuddin father.
Lordship.
Very well. Proceed on. Which matter will you show?
Land document we have annexed, my lord,
Page
page
number?
23, my lord,
20.
23.
Who is the father?
Here, my lord, Pozumia, Pojudian Pozu.
No, Faizuddin, Fozu, Kasimuddin, Kozu.
Pozu, my lord. And during the lifetime of father, my lord, she, my lord, he, my lord, shown an affidavit that he is the Pozu and Pozu, my lord, is the same and one person, and that's he himself, my lord. And in the Jamamandi copy, my lord, and father died in.
That is his own self-declaration. How do you know?
And in the Jamamandi itself, my lord,
Suppose,
somewhere Pozu and somewhere Pozu.
today you filed a declaration, you are a multi-billionaire. Will you become one? Without attending material.
And
So this is the difficulty. And did you ever have two names in your life?
No.
You are always Arali.
No.
We know you. Why do these people, they always have 3-4 names?
in village, my lord,
Somebody said village.
but
No,
someone,
the villages and towns in India, nothing different.
now, my lord,
I think there will be many who also grew up in villages also.
now these are, my lord, not repeating, my lord, because, my lord, earlier days it was occurred.
No,
Now, my lord, presently, my lord.
nothing like that.
Presently, my lord.
When the person comes and gets hold of an identity, acquired identity, from that stage onward, it is consistent because you have already got your identity. Say in 2005, 1990, you get hold of an identity from that stage onwards. Madam Verma also made that same submission, that your every information is consistent. But before acquiring that identity, you have to link up yourself with somebody existing.
Right.
Here the problem comes. Then either you have to change your name to some extent, or we have to change your village to some extent.
And in the,
So
in the
now how do
Jamamandi,
you accept these kind of materials? That
in the Jamamandi itself, my lord, his name has been shown two different name in the same Jamamandi. All the,
see, normally people who tries to avoid the law, in many cases, you find them known by more than one name. But the people who are ready to embrace the law, very rarely you find two names. It's always one name. Tell me which decent person who never was confronted by the law having two names. And it is not that in villages you are known by 3-4 names. We know a lot of people with
everywhere.
village background who grew up in the villages only. They never had more than one name. But why these people? One thing, let the SP make an inquiry. If Faizuddin, then that is, now the difficulty is the SP also always gives a favorable report. Only one liner.
Yes, sir.
No reason also for the SP. So once he passed the order, he will go and approach the SP and satisfy him. And he will send a report. Yes, it is one. Yes, Mr. Dilip Majumdar. How do you address this problem? Till now, we have asked the SP to, that is about quite a few number of cases. Report is always, it's a one-liner report that he is the same person. In one of these, we are going to confront the SP, why is he saying so? Because submitting a incorrect report before the court is also a contempt, mind you. The existence of a fact does not depend on the discretion of the SP. We have acted on it. We have passed our orders in favor of the people, taking note of the report of the SP, but slowly the confidence is coming down.
Proper inquiry has to be.
Because in not a single one, the report is coming that no, we found him to be different.
Always same person.
It's always the same. And no reason, nothing.
That is right.
And they'll write a big paragraph. The court in its order dated these,
Which
Uh-huh.
are matters of record.
that will contain about 95% of the report. And it is found that they are the same person. Invariably, almost. In this case, you keep an eye on what report comes. It is claimed that Faizuddin of the voters list of 1966 of village Digirpar is the father of the petitioner. But again, But again, a certificate is relied upon which says that Basiran is the daughter of Kujumuddin of Digirparam village. A further document refers the father of the petitioner as Kuju, whereas some further materials refer him as Fuzu. In the circumstance, a question arises whether Faizuddin, Fuzu, Kujumuddin, and Kuju are one and the same person. The superintendent of police Borbeta to cause an verification and submit a report. A copy of the order be made available to Mr. G. Sharma and Home Department for doing the needful. Finally, we pass this order, let us see. Sometimes it may be yes also, not that every case is wrong.
But then report should be clear that what kind of inquiry they have done, what they have.
And they'll give you a bunch of paper also, why they say. But nowhere indicated where those paper, which material those papers shows that it is so.
Copy of the order.
Already provided.
Item 23.
School certificate, Mr. Mojumdar, it's almost as good as out of the 10 original records we verified, only one was accepted. 9 out and out manufactured and fake. Sorry.
Tribunal should go into all these things.
This is, they are not doing anything. That's a difficulty. Yes, Mr.
Malota, page Malota 79, Lordship will find Malot parents' name appeared.
79.
79.
Who are they?
Malota
Who is the father?
Solua Ali, father.
Solua Ali is the father and
Jannatun Nisa, mother.
Janatan Nisa is the mother. How will you show that they are the mother and the father?
Malota, the Gaubra and Malot the villagers, co-villagers were examined before the tribunal in their evidence.
Was the requirement of Section 50 Evidence Act satisfied?
Section 50.
of the Evidence Act.
So,
Are you aware what is section 50?
not
The petitioner to submit on the next returnable date as to whether in respect of the deposition rendered by the Gaumbura
and
as
co-villagers.
DW,
Co-villagers.
Gaumbura DW,
Gauburamala DW2,
DW2 and the other co-villagers as DW
3.
3. The requirements of section 50 of the Evidence Act have been satisfied. Rest also.
1st August. Item 34.
Mr. Mondal. What is section 50? What is section 50 of the Evidence Act?
But I have to say it, but basically, my lord,
Section 50 is if an opinion has to be rendered as regards a relationship, then any person of the family or otherwise may be anybody in this world. If they have the special means of knowledge of the fact. So did the Gaumbura have the special means of knowledge of the fact he had certified?
yes,
He had.
we will, yes, my lord, that is happening.
Are you sure he had?
Yes.
Why? The Gaumbura is
Not-
your man who
Same,
stays in the
same
house.
village, my lord, he's personally known.
Same village.
Yes.
There are thousands of people living in the same village. Do you mean to say every 1,000 people knows everything about the other
But
1,000?
he stated, my lord, he used to, my lord, go his residence.
So the Gaumbura visits everybody's house. He is a
Particularly
very
His residence. my lord.
public oriented
Since there
Gaumbura.
is a relation between her father and the Gaubura. my lord. That is. what
Actually, there
has
is
been-
also a relation between. You examine and tell us. If you satisfy this, well,
Well.
good. Just next item. Habibur Rahman.
Lordship, father of the petitioner is Sikandar Ali.
Sikandar Ali.
Yes, Lordship,
Which-
page 50.
Bhetamari too.
Yes, Lordship.
Sikandar at
Serial 3, Lordship.
Ayman Nessa,
Ayman Nessa is the mother of the petitioner.
mother. And who is the father?
Father is Sikandar Ali.
Where is Sikandar Ali at page 50? 50,
50, Lordship.
50,
50.
50. Yes, it is better. Secondary is the father and Aimona is the mother.
Yes, Lordship.
Now which document will show?
Page 63, Lordship.
60. What is this? Land document?
Yes, Lordship. Jamabandi.
Bhetamari too. Habibur Rahman. No. Amina Khatun, the son of second. Yes, Mr. Sharma.
Yes.
Lordship may remember.
Page Betala Land Council for the petitioner. The petitioner Habibur Rahman had been referred to the Foreigners Tribunal number
Number 11, Barpeta, Lordship.
number 11 Borpeta
Page 30.
for rendering an opinion as to whether he is a foreigner under the Foreigners Act 1946, resulting in registration of case number BPT 11 FT 1011 2016. Tribunal rendered an opinion dated 8/8/2022 declaring the petitioner to be a foreigner. In the writ proceeding, petitioner relies upon the voters list of 1965 of village Bhetamari to police station Horbok, Moza Khariza Bizni in the present Borpeta district, which contains the name of Sikandar Ali, son of Amiruddin at serial 3 and that of Aimona Nessa, wife of Sikandar at serial 5, and both are shown to be residing in the same house number 1. The voters list of 1970 of village Betamari Troop also contains
Contains the name.
also contains the name of Ayman Nessa.
No, Lordship, this is aunt. Uncle and aunt name is there, Lordship. In this voters list, 1970.
So what happened to Seconder then?
Seconder died, but mother's name appeared in the year 1985, Lordship.
In between what happened? Mother went somewhere.
Complete voters list I will produce,
And there is a shifting.
Lordship.
also.
Sorry,
There is a shifting also. There.
which place?
but I can prove my
Lordship,
shifting, Lordship.
1965.
No. If by virtue of the land in the same original village, there is a mutation in favor of this person,
Yes.
the shifting doesn't matter. Then you need to prove that Habibur of that mutation and the present Habibur are same or not.
Yes.
You make a verification.
Yes.
The petitioner relies upon the Jamabandi in respect of a plot of land at village Bhetamari 2, which contains the information that the name had been mutated in favor of Habibur Rahman, son of Amina Khatun, Bidhoba. Amina Khatun Bewa, who is the wife of Seconder Ali. The information contained in the Jamabandi may prima facie indicate that Habibur Rahman is the son of Seconder Ali of village Bhetamari. As Ali, the burden under section 9 may have been discharged. In view of the above, remanded back to the tribunal to examine the voters list of 1966 as well as the Jamabandi. The petitioner to also produce the complete voters list of all the years between 1966 and 1997. 1997 of village Bhetamari 2. For examination of the respondents, Mr. G. Sharma, lying of petitioner, states
1965.
objects by stating that there is also a shifting of the petitioner Habibur Rahman
Yes, Lordship.
to another village, namely,
Bhetamari to Nisuka.
sorry,
Bhetamari to Nisuka.
to
Nisuka.
Nizuka.
Nisuka. NICHU.
In view of the above, the respondent in the Home Department may make a verification to find out as to whether Habibur Rahman of the village Niz, it was it to call it, and the Habibur Rahman whose name appears in the Jamabandi in respect of a plot of land at village Bhetamari 2 are one in the same person. Doing the needful origin not every past.
35.
Yes, 35. Years. Niranjan Namasundra. As paid for list in the next week. You're already under interim.
Yes, Lordship.
So how do you prove your case?
Father is Gagan Chandra Namasudra,
Page number.
page number, Lordship. What is it? 78, Lordship.
Page 78. Certificate of registration. In
Yes,
whose name?
Lordship.
Nobody's name.
No, it's name, because it's written, I can provide the original. It's very blurred
So page 76 is nobody's name.
in this, because in my Xerox also same thing, Lordship. Because the certified copy, original, it's ink pen written, Lordship.
And then page 78, Satra Moinbari. 66.
Yes, Lordship.
Who is the father?
Father is Gagan Chandra Namasudra.
Kogan Chandra Namasudra
Namasudra.
father. With Nitawala mother.
Yes,
Which material will show he is the father?
Lordship, page 83.
83.
There is shifting, Lordship.
I will prove the shifting.
No, Lordship.
Hmm.
No, Lordship. From Borpeta, they came to,
How will you prove the shifting?
shifting was not.
How will you prove it? The petitioner may provide any relevant material which may show that Gagan Namasudra, father of Niranjan Namasudra of village Rajabari, as depicted in the certificate at page 83, and Gagan Chandra Namasudra at serial 166 of the voters list of village Hotra Moinbari are one and the same person.
Lordship, it's in the name of Niranjan Namasudra. It's in the 83 is in the name of Niranjan Namasudra.
That's why I put it in the reverse way. Gagan say father of Niranjan.
Father did not shift. He came, the father died in Barpeta. He had shifted along with his rather younger brother.
Are one and the same person.
Give you.
Our question is set. Gagan Namasundra, father of Niranjan, as depicted in that certificate of
Yes,
Rajabari, and Gagan Namasundra of 65, they are the same person.
yes. That through section 50.
Sorry,
I can prove that through section 50.
no, you cannot.
But one
You
reason,
cannot.
because those person who were residing there,
Section 50 is only to establish relationship. There is a
relationship,
case where that two entities are the same.
yes, Lordship, that,
50 is not applicable, something else is applicable.
I'll make my case, Lordship. On the next. day.
36 for hearing.
May I please,
36 years.
The petitioner is my lord Haripath Karmakar. His
Uh-huh.
father is Jagadish Karmakar.
Page number.
Page number, my lord, annexure 1, my lord, page 12, my lord. 13 is the vernacular, my lord.
Sorry,
Page 12, my lord. 1,
page 12. Both document.
refugee registration certificate.
Both document decision. Full certificate.
Photo, yeah.
Refugee registration certificate,
My lord,
certified that. Hmm,
Sri Jagadish Karmakar.
that is Jagadish.
Jagadish Karmakar. Jagadish
How did you read it? How did you read that it is Jagadish?
This is very dim impression, my lord, but
Sorry,
maybe the impression is very dim, my lord. But it is
impression.
in the vernacular, my lord, it is very dim impression having.
No,
Jagadish is there.
do you have any special means of knowledge to read that this is Jagadish? Because we could not read it. Because it is absolutely not legible.
Jagadish.
How did you read it?
I want to record as Jagadish Karmakar.
Anyway, forget about it. This is a refugee certificate in the name of, you
Father
claim
of
to
the
be Jagadish.
Jagadish,
Jagadish is the father.
father.
Which document will show?
My lord, annexure 4, my lord, page 17 is the school
Annexure
transfer
4,
certificate.
page 17,
My lord,
school certificate.
Lordship,
You have
school-
produced it.
Lordship,
What is the look of this register?
This is the, in the year of 1970-71, he got admission in class 7. School attendance register is also there.
Jagadish Karmakar of a village.
Village
Pithadi.
Pithadi.
Where did the name of Jagadish Karmakar appear? In any voters list?
Jagadish Karmakar, my lord, his name appeared in the voter list, my lord, after shifting, my lord, page 20, my lord, voter list of 1997, my lord.
1990?
His name is not there, my lord, in the annexures, but the name of the petitioner is there. Jagadish.
Page number 20.
Page number, my lord, 20, the voter list of 1997.
This is Haripada. Who is
Haripada.
Haripada?
Haripath, Haripot is the petitioner.
1997, 97 it will come.
Yes.
How do you know Jagadish is a citizen?
My lord, accept the refugee registration certificate.
Sorry,
Accept this, my lord, refugee registration certificate, my lord. And most probably the, my lord, the entries made in.
on
the-
which date he took admission?
Yes,
On which date this Haripot took admission?
Date of admission 26/5/1970.
1970.
Okay.
So I think, who is appearing? Yes, Mr. G. Sharma. If the man took admission in 1970, that was before 25/3/1971.
Yes, Lord.
So that by itself is good enough.
Yes, Lord.
At the best, he can be between 66 and 71.
Yes.
You will examine?
Yes.
Send it back.
right.
Yes, Lord.
Heard Mr. No? Mr. Jed Hamad, led counsel for also. Haripot Karmakar had been referred to the Foreigners Tribunal number 5, Morigaon, for rendering opinion as to whether he's a foreigner or individual, resulting in registration of FT case number 2112/2012. Oh no, it's old number. That is case 57, 129, so 2016. Tribunal in their opinion dated 38/2017, declaring the petitioner to be a foreigner. Being aggrieved, the writ petition is instituted in the writ proceeding. The petitioner also relies upon a transfer certificate issued by the headmaster of Bagodi Government Aided Higher HE School. HE মানে কি? ME Middle English, HE High English নাকি? HE. HC School at village Bhela in the present Borpeta district, which contains the information that Haripot Karmakar, son of Jagadish Chandra Karmakar, is a resident of village Pithadi. In order to verify the authenticity of the information contained in the school certificate, we also required the education department to produce the admission register in original of Bagodi Government High Aided HE School. Upon perusal of the admission register in original, it is discernible that Haripot Karmakar was admitted in the Bagodi Government Aided HE School on 26/5/1970, meaning thereby his presence in the state of Assam was established to be prior to 25/3/1971. In view of the above, remanded back to the tribunal to examine the claim of the petitioner. Petitioner may produce any relevant document which may show that Jagadish Chandra Karmakar of village Pithadi, as referred in the school certificate, is otherwise a citizen.
My lord,
Upon doing the needful, a reason order be passed.
I live.
So worst is you can be 66/71.
My lord,
But for the other part, you show the presence of your father.
No.
Kitab Jan Begum.
my lord.
Yes.
In this case also, my lord, the records were called for regarding school certificate from the government.
This one looks like a old register.
Yes. And the, on last occasion also, my lord, lordship,
In the morning, somebody produced a register,
Right.
which appears it was bought from the shop the other day. You can make out, it's a brand new one. Right, from the Tripura.
but here in this case, my lord, on last occasion also, my lord, we have seen that the entries are very clear, my lord, regarding the,
Yes, already seen it.
my lord, on 12th of, my lord, this month, lordship was supposed to, my lord, declare him, my lord. Otherwise not remanding back, my lordship.
But why it was not done?
Because, my lord, she took time, my lord, last occasion.
She took time. Yes,
Because when
sorry, a little louder.
Oh,
You have covered the microphone, therefore your sound is not coming.
Entries are very much clear, lordship, in except the petitioner lordship.
No, do you agree with it?
No lordship.
You do not agree. Why?
It shows lordship. Lordship,
Adjourn on the prayer of Mr. G.
Lordship.
Sharma, like counsel for the Home Department to examine the admission registered in origin on the authenticity of the contents thereof.
bec-
List on swings. Just next slide.
Lordship may. Yes.
See, Mr. Sharma, if we agree, we can pass the order. If you disagree, you examine and tell us.
Yes, Lord.
Which one is yes?
Yes, Lord.
No, yes is relating to agree or disagree.
Agree, Lord.
Oh, he was agreed. What information is available there?
Yes, Lordship. A date of petitioner.
Date of admission?
In date of admission was 1/2/1988.
1/2/1988. Okay, very well.
He
Then
left the school on 31/12/1989.
and
31.
who is his father of which village?
Father is Lordship Ramzan Ali. Ramzan Ali, it is.
Of which village?
So, okay. Moira-
Village is Moirabari.
Moirabari. And where is the name of Ranjan of Moirabari? Which
Page 12
for
of the petition.
page
12, my lord.
12?
My lord.
But entries are made belatedly, Lord.
Huh?
Entries were made in the year 2007, Lordship.
Okay, we passed the order. You examine and tell us.
In fact,
Next.
my lord, I'll have a prayer, my lord. Lordship will kindly, my lord, examine, my lord. After going through that.
Okay, his examination is not dependable.
My lord, it seems that, my lord, the entry is absolutely clear, my lord.
Okay.
My lord.
Entries were made in 2007.
Yes, Lordship.
Sorry.
It is.
How a admission of
Same
98 can be
handwriting.
made in 2007?
Other
Next video.
handwritings are different, Lordship.
Next video.
Other. Others handwriting are different, Lordship. This one maybe.
Item 37.
We'll see it on the next page.
Yes.
37,
38.
38. Yes, Mr. Islam. Responding Home Department to make inquiry, submit whether Karimun Nessa of, you have the report.
No, Lordship.
Adjourn on the prayer of Mr. G. Sharma, Home Department for the report as required by the order of 8/6/2023.
Well, maybe taken about Monday, my lord, Monday or Tuesday.
Monday or Tuesday.
Okay.
Take it up this side.
Report and see.
Nine. Supplement.
39.
Sahirul Islam. Yes, Sahirul Islam. You represent admission register in origin.
Lordship. This is not in good condition, Lordship. The records is not in good condition, Lordship.
What is the information contains? Does it support the petitioner?
Yes, Lordship.
It supports the petitioner.
Support the petition.
Now, where is that school certificate? Page number?
Page 29.
29. Hila Pakri, High Madrasa. Sahirul Islam, son of Janu Munshi, village Jaipur. Where is the name of Janu Munshi, village Jaipur?
Page 16, my lord. 16.
16. Janu Munshi, village Jaipur. What did you? Heard, Mr. You were also LIS, which one? Mhm. What's your name? Because you also have LIS. So which one to that? A Moti, heard Mr. A Moti and counsel for the petitioner. The petitioner Sahirul Islam had been referred to the Foreigners Tribunal number
Foreigners tribunal.
number 10 Borpeta for rendering an opinion as to whether he's a foreigner, resulting in FTPS number 294/16. Opinion dated 14/11/2018, declaring petitioner. In the writ proceeding, the petitioner realized, you're having second thoughts or what?
Lordship.
Are you having any second thoughts?
No, Lordship.
No, you're very minutely even looking at the records.
No, Lord. First page is Lordship of class 2 and the which page I am looking here is class.
Or you want to examine it further, then we adjourn it. They have some doubts on that.
Serial number is same.
List of the other. Thank you very much. Yes, next item. KDB. Adjourn on the personal inconvenience of MS KDB, then counsel for repetition. Yes, next item. Yes, is it progressing?
Yes, Lordship, from 10th of June, regular checking has been done.
No, no. Progressing. Could you locate any contaminated?
Lordship, as per the agriculture department report, 28 samples were collected. On finding using that Bhabha Atomic Research Kit, Lordship. So 28 sample have been detected and they have been analyzed by the Food Safety Commissioner. Lordship, he can tell about the outcome. And Lordship, awareness has been created and the farm.
No, is the problem coming down?
May it please your lordship, as per your lordship, last order, your lordship, I have visited more than 7 to 8 market of Guwahati. And
It appeared contaminated or it appeared very clean?
in this regard, your lordship, I would like to submit a report, your lordship.
Report.
Yes, by way of affidavit, your lordship.
What is this?
This is the food and safety.
Achha, if you have put up this advertisement.
Yes, Lord, the poster and everything has been done. We have conducted the test on 10/6/2023 using 13 of this.
So the vegetables are clear,
Negative. On those
mostly
two
clear
days,
because negative.
All negative.
A preliminary report has been also produced by the Consumer and Key
Commissioner.
Department, the Food Safety Department,
Yes, sir.
which
Commissioner-
shows that some testings are being carried out. As Bhuya learned petitioner, the petitioner person states that she had also been visiting the vegetable markets in and around Guwahati and would like to submit a report of the findings that may have findings pursuant to such visits. A list on when do you want?
After vacation, your lordship.
A list of
8th August.
Obliged.
and all the departments involved are required to carry forward the process.
Yes.
So that contaminated vegetables are eradicated from the market.
This
Sorry.
may be kept as a part of record. Lord.
Put over it. Oh, this one we can put it in our wall, the big one.
Poster.
Obliged, lordship.
Timing item 2.
Two timing. What is item 2? Why was it timing?
My lord, I was in court number 3.
Yes, what is the matter?
I have collected some papers, my lord.
Maya Bormon.
I may be given opportunity to file an affidavit, my lord.
Mr. S. C. Bisal and Honorable Minister prays for adjournment to file an affidavit. Prayer, Lord.
Item 42 to 59 for hearing.
Mr. Chaudhary. Mr. Chaudhary, just. Any of the Chaudhary will do. That poster thing, I think there is a nearby vegetable market here. Is it available in that one?
Lordship, that information I do not have. Lordship. Is it
The
available?
green poster,
Yes, yes.
I think we have a very big vegetable market
Market,
just adjacent on the backside.
Yes, Lordship.
Is it available there?
That information. We can put Lordship on.
You make this circulation.
Yes.
The people should be made aware. Actually,
Yes.
it's not a very bad idea. Bring in more of this near all places where vegetables are sold.
Yes, Lordship.
Or make, put up a paper publication also, not bad. But that poster is very good. It's effective.
It can be done, Lordship.
Since more the people are made aware of the problem, only then it can be eradicated. Otherwise, never.
Yes, Lordship.
And most people buy vegetables by the look of it.
Yes,
And the better the vegetable looks, the worse it is. Always.
yes, Lordship. More
Something
pesticides are
which
used.
you feel like eating moment you see it, that's supposed to be the worst of the vegetables.
How less, Lordship?
Very fine.
My item is item number 47. Now, my lord, so far as my readable is concerned, the only issue that requires consideration of your lordship is whether the government can provide for reservation in promotion without collection of quantifiable data and without forming an opinion on that. That is the only issue to be determined in my repetition as well as the NDFA.
Yeah, surely in your case, what we propose to do, let us read the earlier order first.
Yes,
I think that will
yes,
put us in a better position.
because my lord, one of the
Let us read what that order contains and what is the requirement. Now for the issue you are raising, it's basically implementing what was provided by the court earlier,
yes,
whether it had been adequately implemented or not implemented. If it is implemented, we can form a view, yes, it is required, had already been done. If it is not implemented, we require them to implement the earlier court order.
yes, my lord.
I think that's we need not decide the issue once again, what had already been decided by the court.
Quite true, my lord.
Well, how do you feel, Mr. Mojumdar? Hmm.
As a matter of
And
fact,
by reading 2016, the initial direction it took may give an indication that it was an endeavor to implement that earlier order.
Yes.
But if you read the order further, it may not be so. Or it may be so. Both. We'll hear you on that issue. If it is yes, then that's the end of the matter. If it is no, you do it. And we don't mix up this issue with the other one. Other one is a totally different, on a totally different pedestal.
it is consequent. It is consequent upon reservation.
It's on a totally different thing.
Unless, my lord, the reservation is provided, that consequence relief, that question will.
But that
also
will,
arise.
if the reservation goes, consequential also.
Automatically.
Because the word itself is consequential.
Yes.
If the source of the consequence is not there, how can there
That's
be?
why, my lord, on the first day I submitted that my case should be taken out first, so that, my lord, if my petition is allowed,
But it is on a totally different pedestal.
anyway, my lord, I am not for that.
Because allowing, we cannot. We can pass two kind of orders. Seeing the OM of 2016. If it is a good compliance of the earlier judgment of the court, we declare it accordingly. If it is not a good compliance, we require them to comply with it.
No, my lord, perhaps the court will not like to issue a mandamus to go for reservation and consider it.
We'll
Only-
never.
Fine.
We'll ask them to comply with the earlier order, whatever it is.
Yes,
We are not going to add nor going to take away anything from that order.
my lord.
Hmm.
Well, one submission I have to make in respect of this petition
Yes.
of my learned friend.
Over. I saw light video one.
Spine bend.
This one don't really disconnect with video. Third full video, but it's not really video.
Well, regarding this writ appeal,
which was, of course, the writ petition was dismissed. How this is how they have come before your lordship in appeal. Their challenge is only to the OM of 3/8/2016 on the ground that reservation promotion was provided without following Nagaraja, which says that you have to collect quantifiable data. Without that, you cannot provide for reservation. And I've got just one page reply for that, possibly in this writ petition.
One page or one line?
One page.
One page.
I'll just read that now. One page for this case, my lord, and the other 2 pages in response to Mr. Das's case, my lord. I may read out. The only prayer in the writ petition is to set aside the OM dated 3/8/2016, whereby the government of Assam provided for reservation promotion in
But
services.
Mr. Mojumdar,
My lord,
suppose we set aside,
my lord.
but reservation in promotion is provided by section 5 of that act of
This
1978.
is what I have argued here, my lord. May kindly allow me to read. This is what I have said.
If you,
That is what my.
if you want to say that, why do you want to again repeat it?
My lord,
We have already understood it.
my lord, that is why I said unless they challenge the act. They
No,
cannot.
that we don't know. It's their prerogative,
My
but
lord. My lord, that is my submission.
whether or not reservation had been provided by the OM of 2016,
My lord.
it had already been statutorily provided by section 5.
My lord, that is why I'm linking it with the judgment of Nagaraj. Nagaraj said it's not a case of reservation. It is about extent of reservation. Now the extent of reservation percentage is given already there in the act in section 5. Now if by
Sorry,
OM is, my lord, the extent of reservation is already provided in the
percentage,
act. Percentage.
10%, etc.
10%. That is the extent of reservation. That is already provided in the act. Act has not been changed. How can the OM be challenged to say that you have not collected quantified data? Just one paragraph from Nagaraja, I'll just point out, just one paragraph, and this section 5 matter. That will suffice. That is my submission in this one page reply matter.
লুইচ দিয়া নহয় নাগাৰত দিয়া নহয় না লুইচ ইয়াতে আছে নেকি কিখানে কথা দিছো I think Nagaraj has not been bound. But give this same copy where I made the earlier markings. নহলে আকৌ প্ৰত্যেকবাৰে বেলেগ কপি এটা ললে you trying to lose your track. নাগাৰাজটো বহুতবাৰ মাৰ্ক কৰিছো মই সেইটো নাই নেকি ঠিক আছে দিয়ক no এটা হলে কি সুবিধা হয় by your earlier markings you tend to recollect whatever is there. That's why to avoid the repetition, I got it bound.
Yes.
Otherwise, what happened on every day, we are given a new copy.
New copy.
And if it's a new copy is given, your earlier marking goes. So you can't link up
Yes.
what is stated there.
Well, from the judgment, Lordship will kindly see. I have mentioned matters. Paragraph 123.
এতিয়া পৰা এইটো কপি দিব মানে next time I don't change it. Paragraph
123.
123.
Will be page 278 of the judgment.
নাগৰাজটো বাইণ্ডিঙত অহা নাই বেলেগ কপি আছে নেকি Itu di bawah oleh
Para 123, I'm reading.
123.
Page-
123, we have already read it. I think it's
Well,
already
yes, yes.
marked. Huh?
Yes, yes.
Huh. However, in this case, as there a main issue concerns the extent of
Yes.
reservation.
In this regard, the state concerned will have to show in each case the existence of the compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision for reservation. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SCs and STs in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of class and inadequacy of representation of that class in public employment, in addition to compliance with Article 335. It is-
No, Mr. Mojumdar. 123 is a test given by the Supreme Court.
My-
If you want to have either bring in or continue or have reservation in promotion, what will be the requirements?
Yes.
This is for the past, present, as well as future,
Yes,
whenever you want to bring in reservation.
Right.
In our state, if you read section 5, what does it mean? Has the reservation already been statutorily brought in or it is not been brought?
brought in already.
Already brought in.
Oh, yes,
So now there is no question whether
yes,
reservation should be there or should not be there. It is
Exactly.
already there.
yes. that is
So
my
now, if you want to challenge
Madam.
the reservation which is already there
Madam.
by putting a test as per
Madam.
123 of Nagaraj, then whichever provision had brought in the reservation
That
has to be put to challenge.
Well, that is my submission.
Once we interfere with that,
Madam.
reservation will go away.
Well, that is my only submission in one page reply, madam, and nothing else.
And if that happens,
Madam.
here in the instant case,
Madam.
that OM of 16 is being assumed.
Yes,
Is it a case that OM of 16 had brought in reservation in promotion?
no,
Is it a case it had been continued?
Madam, that's what I say. That is why when Nagara says about the case itself is about extent of reservation. So for
So therefore, I wanted to see what the earlier judgment provided for. What did it
Of
provide for earlier judgment
equality
in equality forum? This is. Schedule caste act. What's the name of that act? Schedule,
yes, ma'am, it is
got it. Schedule
Assam-
Caste and Tribe Act 1970.
Assam Scheduled Caste and Scheduled Tribe Reservation of Ports in Services Act 1970.
71. But difficulty as in come from next week, this bench will not be there.
My lord.
This bench will not be there
Oh,
from next week.
in fact, my lord, I'm feeling that only that the IA was filed because some.
So that's why I'm thinking that I wanted to complete it today itself. If you can complete it,
I can complete my, I'll take only.
otherwise.
Possibly. we can-
Initially, it was expected that
Yes.
up to the vacation, the same bench will continue, but from next week, there is a change.
Different bench. All right, I can complete within another 15 minutes to the next.
Justice Khaun will be
Yes,
with me on the next week.
since my lord, it has been ordered as
No,
part of.
now we don't want to leave it. After spending so much of time, I
Yeah,
don't
yeah.
believe in again those. Things.
So many days, my lord, lots of this.
Everybody had argued. We have also understood something. If our understanding is wrong, Tested in appeal, if the understanding is right, accept it. Bisa aku restore back over. And plus, if we defer it further, you forget everything. It's not easy to retain so much of thing. That's why I prefer the daily one. Daily, what happened? Everything is refreshed, then you. If you have understood something wrongly earlier, today's submission will bring in correction. We do that. We edit that way.
Or maybe, my lord, I don't know. We can, because my lord, I don't have much wrong to argue, except my lord referring to certain paragraphs of the Nagraj judgment and.
No, Nagraj ultimately culminates in 123.
Yes.
Although the earlier judgments were some of the reasoning why the court is heading in that direction, but ultimately it's 123 only.
Only one word in the paragraph 123 will not, my lord, decide the, will not reflect the ratio decided in that.
No,
case.
no, which word?
Extent of reservation. That is what my learned friend has submitted, my lord. What I understand from his submission.
No, no. That submission is not very acceptable because however, in this case, that is the case of Nagraj, extent is involved.
Yes.
But the general proposition is,
Those are earlier, my lord. Given.
if you want to bring in reservation, what are the tests that has to be satisfied?
Yes, exactly.
And the test that is to be satisfied is quantifiable data.
Yes.
If you read everything. So there is a requirement to undertake an exercise of finding out the quantifiable data.
Then form an opinion.
There may be a little variation as to what is quantifiable data.
Yes.
A little, some judgment, a little this side, one little the other side. But quantifiable data requirement is consistent all throughout.
Yes.
If that is so, now question is whether reservation in promotion is already available in our state. If it is not, then the reading will be, if you want to introduce it, you'll have to follow that condition precedent. If it is already existing, it has already been brought in, either having quantifiable or not having quantifiable. Only option will be to challenge that provision bringing in because the requirement of quantifiable was not satisfied. Then the court will examine whether that will be acceptable or it will not be acceptable. And here is a case we have that OM of 16 is under challenge on the ground of it being without quantifiable data.
Yes.
We explore a little ahead. Suppose we hold it to be yes. There is no quantifiable data. So 16 is unsustainable. If we declare that, will the reservation in promotion go away? No, as long as section 5 remains, it will not go away. So, number one. Secondly, we'll read OM of 16 once again and try to find out whether it leads to a situation that it had introduced reservation in promotion. If it has introduced, then maybe it will require a setting aside. But a factual determination would be required to do whether it actually brings in or it is of something else.
The whole issue hinges on the petition of equality forum.
that the reservation could not have been brought in because the quantifiable data was not there.
Understand, that's right.
Lordship, one thing has been missed out, the 2016 OM clearly specifies what is quantifiable data, which the petitioners have not stated. The Lordship will take up clause 6. It states that the quantifiable data is the cadastre.
এই কিবা হেৰি মাৰি স্প্ৰেতে মাৰি আছে নেকি? কেমিকেল গুণ এটা আহি আছে। নহলে এইবোৰ লগাইছে নেকি? এই যে স্যানিটাইজার মাৰিছে নেকি? Some strong smell is coming. Yes.
So Lordship will, if your Lordship takes up page 31 of the RIT 239. Lordship, the clause
Mr.
6
Das, what we are actually has already opened the book. Understand section 5.
Yes.
Section 5 is reservation for members in a post to be filled up by promotion in a shall be regulated. And manner, there shall be reservation at 7%. Means reservation in promotion. So it is already provided.
Yes, but this is one of the ground. The section 5, in fact, the learned single judge has rightly held that the power of reservation flows from section 5 and amendments 5A. So at no point of time, the OM of the petitioner, Equality Forum, saying that it is in violation of Supreme Court order can sustain. Because without challenging the parent act, how can an OM now take a override an act? The act has already, source of power is already there. And section 6 of the 2016 OM specifies.
No, 5A is only manner and procedure.
No, I'm talking about the OM of 2000.
No, 5 is providing for reservation.
Reservation,
Huh.
roster promotion,
Huh.
roster.
Hmm.
In fact, quantifiable data has been explained by Jadel Singh, clarified Nagraj and said that quantifiable data is a cadastre, nothing more.
Or whatever it is.
So
We are not venturing to that
yes,
extent.
because Jadel Singh was also. referred
Because,
to
Mr. Das, this is a subject. If you venture into each and every aspect of the matter,
this.
neither the hearing will conclude, nor will he will pass a judgment, and even if you pass a judgment, you don't know how big it will be. And it will add only to the confusion. So let us stick to the issue involved. Here, Equality Forum had assailed, here, Equality Forum had assailed OM of 16. Let us see why it was assailed. Where is the writ petition? Is it annexed anywhere, writ petition? In the,
Your lordship will find.
IV Dasgupta, WA 46.
Page 38 is the, my lord.
Hmm.
No, sorry. Page 38 is the.
Hey, go on. এই হেৰিখন চাওকচোন ৰেকৰ্ডত ক'ৰবাত আছে নেকি? WPC 5026 ৰিট পিটিশনখন আছে নেকি?
Well, it is there in my appeal, my lord.
Sorry,
In my appeal, it is annexed,
your appeal is number
239.
239 to দিয়ক। Page number.
No, put a paper nine. The entire petition is not there.
Hmm.
Only
It's
the
not there.
annexes.
No, I just wanted to go through what exactly is challenged there. Nine, record to nine.
No, my lord, this is the. Page came on.
You need to appeal hole to সাধাৰণতে
Starts as 41.
লিষ্টত নাপাব এটাতে ৰেকৰ্ডত আছে নেকি?
The petition starts as, my lord, page 41.
41. I want to get a key here. Wait, you said to you. 41, writ petition. Writ petition.
whereas at page 55.
Hmm, hmm. To issue writ setting aside 16. Resin 2016. Quashing all promotions, that is the consequence. Issue mandamus directing response comply with requirement of 16(4)(a), as well as the apex court's pronouncement as regards conducting fresh preliminary for forming opinion and even need of reservation. We issue mandamus directed to forbear from making any provision for reservation in the present promotion. So 4 and 5 prayer number, the section 5 will of the act will come on the way. Had it been the case that the reservation in promotion is provided only by the OM 2016, then it is okay. We set aside OM of 2016 by holding that quantifiable data exercise was not undertaken.
I understand.
And once that OM goes, the field now remains open. Then the prayer number 3 will come in as the reservation had been taken away. So therefore all promotions may be also interfere. And 4 will come in to conduct a fresh preliminary exercise to form an opinion because the 16 is gone, providing for reservation. But suppose 16 goes also, section 5 remains, and 5 is very explicit.
No, my lord, we are not against reservation in promotion.
Then what are you against?
The provision that is there already, we have not challenged it, and we need not challenge
Then
it.
what exactly is
We
challenged?
say that if you want to implement that, then
No,
the
There is a act, there is nothing called the statutory provision and implementation thereof.
my lord, our case in the repetition is that
The
provision is there already in the. in the act.
no, Mr. Sorry, let me clarify. A statutory provision comes into effect on the day the statute is brought into force. There is no requirement of any separate implementation of the provision.
My lord, yes, that question arises because the Supreme Court has already said that if you want to provide for reservation in promotion, you have to carry out this exercise.
Understand? So if you want to do that is in future, you'll have to do it.
Yeah.
We give you an extended hand. If it is already existing, you can challenge that provision by saying that the earlier provision, statutory provision or whatever other provision, executive provision was done without undertaking this exercise. So this will be a very good ground to take up to challenge section 5, virus of section 5.
If section 5 is challenged in another repetition that a division bench is pending, my lord, I will not come.
So you have to wait for that one.
But then, my lord, for this matter to be decided, my lord, since section 5 is not challenged here, without a challenge to the section 5 also, the reservation of promotion cannot be given.
We cannot.
That is what I want. That's why, my lord, I want to read.
No,
the-
perhaps possibly we cannot, because reservation in promotion is provided by section 5.
My lord.
That's why I'm repeating it again.
Yeah.
Had it been provided by the OM of 2016, we are absolutely with you.
That's why, my lord,
But it is not provided by OM 16.
No, that is why, my lord, I was trying to, my lord, improve your lordship, that your lordship will read these relevant paragraphs of Nagaraj, what it has said. That
No.
if you want to implement.
No, we 100% agree with you. Nagaraj says quantifiable data.
Yes.
There's absolutely no doubt about that. But if it is a future bringing in of law in reservation, you have to follow whatever is there in Nagaraj. If it is an already existing provision, you'll have to challenge that provision, that it is not Nagaraj compliant. Now here in our state, the existing provision is section 5.
Yes.
So section 5 may be unsustainable because it is in conflict with Nagraj. It is possible. It's a very good argument. But section 5 has to be challenged.
My lord, for that,
This is where the
I understand your worship, my lord, the query. For that, my lord, I'll like to take your worship to the earlier judgment in equality forum.
that's why I wanted to look. Equality forum, does it set aside section 5 in any manner?
No, it has not been annexed, my lord. It is readily available in the book. 2016 volume 1.
Yes. There is one more aspect and examining. So the Equality Forum says that the collection of data and opinion based on rendered by one-man committee do not conform to the norms laid down in Nagraj. So that one-man, that Sonwal report goes. So Sonwal report regarding quantifiable data is unacceptable.
Yes,
Yes, we agree with it.
yes, my lord. Then, my lord, your worship.
Now, having agreed with it, now if you want to take away the reservation given, section 5 has to be struck down.
No, we are not taking away the provision of section 5, my lord, that provides, but to implement, my lord, to implement that.
This is where we are having difficulty in understanding.
Otherwise, my lord, there was no question.
Then please show a proposition that a statutory provision providing for a particular
That needs to
aspect
be implemented
is
by another.
again required to be implemented separately by an
My
OM.
lord, before that, my lord.
Or
my lord.
by very virtue of the act being brought into force, it is a automatic implementation.
No, that's why, my lord, I wanted to bring to your worship notice the earlier judgment, because in that case, my lord, the section 5 was also. my
So
lord,
now 302 IPC is murder.
yes.
Is there any notification giving effect to 302? Or the IPC being brought in force itself, 302 is applicable?
No, my lord, that the notification when the act will come into force from that.
No, that's a gadget notification.
Yes.
Here also there is a gadget
That's
notification.
why-
I'm very sure it is there.
That's why, my lord, let us understand, my lord, what is there in the earlier judgment.
Earlier in Equality Forum.
Equality forum.
Yes, please read what you want to take.
Your lordship will kindly come to paragraph 44 of the judgment.
Paragraph 44.
Because it is not that, my lord, the earlier OM was set aside, earlier report was set aside without considering the, my lord, section 5 of the.
So
Act.
far as state of Assam is concerned, the state enacted the Scheduled Caste Act 25 providing for reservation.
Section 5 of the state act provides for reservation.
There would be reservation to the extent of 7%. For this purpose, roster had been formed. Yes, following the judgment in Sabarwal, which route?
Then there was an amendment in 2012.
2012 only brings in 5A.
Yes, ma'am.
It's nothing beyond that. It
Yes.
doesn't touch section 5.
No, no. Then in paragraph 46, my lord, another repetition has been stated.
Meanwhile,
mentioned,
division
my lord,
bench,
that is
two
still pending.
cases, one filed had made case, would not take action in violation of the law laid down in UP power.
And this case is yet to be decided.
In the separate proceeding related to reservation, irrigation approach held that there was no party.
Then, my lord, paragraph 47 is important. Right?
47 we are.
Last sentence, it was held in that in the absence of some quantifiable data, the question of forming any opinion by the state to invoke the enabling provision of Article 16(4)(a) would not arise. Accordingly, it was held that till the.
Mr.
exercise of-
Chaudhary, what is the difficulty is Article 16(4)(a) is an enabling provision. Whenever it is an enabling provision, there is a requirement of giving effect to that
Yes.
provision. There it is there. Either by notification or by statute, you give effect to reservation being brought in.
Yes.
But section 5 of the Act of 1978, let us read it once again, whether it is an enabling provision or it is a
It provides for
it
reservation
is providing. So once it is provided,
to give effect to it.
no, this is where.
That is where what the earlier judgment says.
No, but where is that provision of giving effect to a
Your
statute?
Lordship will kindly complete this, my lord, paragraph 47.
No, paragraph will go later on. Where is the provision in section the 78
No,
to again give effect?
No, my, it's not there in the act, in the 1978 or the amended. in
Then if it is not there, from where does that concept comes in from?
This concept comes in because of Nagaraj. That is what I am.
From the judgment.
Yes,
What is the source of that, basis of that
that
judgment?
is why, my lord, I'd like to draw your lordship attention to the paragraphs, my lord.
Please show it.
Now here, so far as this case is concerned, my lord, in the earlier equality forum, this has been clearly held that the state based on quantifiable data, so collected that the enabling provision of Article 16(4) is not to be invoked or carried out. The 1978 Act, as amended in 2012, insofar it provides.
Which
for
paragraph
reservation-
you are reading?
So last sentence of paragraph 47.
47,
Yeah.
Limited.
The 1978 Act, as amended in 2012, insofar it provides for reservation and promotion, would remain in a dormant state.
So where provides for reservation would remain in a dormant state.
Dormant state till when? Till you have the.
This
quantifiable
is what we are trying to understand. How? So none of the statutory provisions are in force in the country. 302 IPC is not there. Any statutory provision statutory you think of, it is not there. Everything is in dormant till it is given effect. That is not the
No, my lord,
interpretation of an
because
act.
this is a judicially evolved principle.
Judicially evolved principle will also got to have a basis supported by law. One line, one word here and there.
Now, these findings are on the basis of primarily Nagaraj.
I understand.
These findings.
Perhaps,
So, after this one,
perhaps
this
this judgment is per inquirium. Even if it is say it is per inquirium to that aspect, that it is not.
I'll satisfy your lordship that this is not for inquiry.
Then please,
Yeah.
please argue.
Before that, my lord, what has been, my lord, settled by this case? Because this has not been appealed against by the state or the private party. So this provision of section 5 will remain in a dormant state. That is the, my lord, finding of the in the earlier round of litigation. Challenging the, and finally what it is said, my lord. I'll not take your lordship to the all the paragraphs. Paragraph 62 and 63.
62 and 63.
63. Paragraph 62, may I read, my lord? Thus it was held that the state.
Now,
is-
before that, Mr. Chaudhary, just one thing. If you see section 1(3) of the 78 Act,
My lord.
it shall come into force on such date as the state government may by notification official gazette appoint.
Yes.
And where is that official gazette? Yes, Mr. Mujumdar, can we have the official gazette notifying this one 78 Act? The day it was
It has been.
notified in the gazette, it
Yes.
came into effect.
Date has been given in the book itself, my lord. Yes. Published in the Assam Gazette, 26 September 1973.
It came into effect on that date. All the provisions of the Act
Yes.
came into effect.
Then
So
no
there is
more-
nothing called dormant. At the best, you can argue there is a concept called casus omissus. Casus omissus is if over a considerable period of time, a statutory provision had not been implemented. In that case, law assumes as if that statutory provision is not there. But this is not a case of casus omissus. Because from 1976, on fact, Mr. Mozumdar, from 1978 on facts, was there any promotion given by reservation in promotion? It was given. So it's not a case of casus omissus. then.
Even now it is being given.
So yes, please argue.
Now, my lord, may I read paragraph 62, my lord? Thus it was held that the state is not bound to provide reservation for SCs and STs in the matter of promotion. However, if the state wishes to make such a provision, which is permissible under Articles 16(4)A and 16(4)B, the state has to collect the quantifiable data showing the backwardness of the class and inadequacy of representation of the class.
Mr. Just a minute. This argument, we can accept it for consequential seniority. The argument you are leading, that can be accepted for consequential seniority for the reason because section 5 does not mention anything about consequential seniority. So to give consequential seniority, there has to be a subsequent implementation and bringing into effect consequential seniority after the 85th amendment. That we can accept. That whichever document had given consequential benefit, if you assail that without quantifiable data, that is possible.
I understand your words.
But other than 78 Act, it will be difficult to accept the
lord,
situation that it
My
is.
humble submission will be, my lord, because this has attained finality, your worship may either hold it to be for inquirium or your worship may hold it to be a bad law. But the fact remains that, my lord, till date, this is the final, my lord.
And per inferium is any legal proposition that had not been brought to the notice of the court while the
That
earlier
was
judgment was delivered.
Yes.
So this proposition that this provision of reservation provision already came into effect in 1978, possibly this aspect was not brought to the notice of the court.
My lord,
Therefore, the decision came that it is dormant.
this judgment has already, my lord, discussed the 1978 Act, my lord, as was pointed out.
But no, but provisions of section 1, 3 and 5 read together, that proposition had not been brought to the notice. What will be the effect of those two provisions or what those two provisions provides for?
My lord, this has given a very, my lord, clear picture about the reservation and promotion. It has discussed the, my lord, 1978 Act. It has discussed the mandate of the Honorable Supreme Court. And thereafter, my lord, these findings have been arrived at. And it's not a, my lord, it's a very elaborate judgment that way. That's why, my lord, I wanted that your worship should read certain paragraph. Thereafter, your worship will.
No, I am not one paragraph. I am ready to read the whole judgment
And
also.
my lord, to show that this is neither for inquirium nor against the, my lord, mandate of the Honorable Supreme Court, I take your worship to certain paragraphs of the Nagaraj's judgment and judgment.
Black's Law Dictionary.
This is the learned single judge exceeded its authority for a simple reason. 78 Act was never challenged. So if it was not challenged.
No, he cannot, no, my lord, he cannot argue against this order. Against this judgment, he cannot argue, my lord. They did not prefer any appeal against that. My lord. He cannot argue.
We
against
did not allow him to argue. We just stopped him. Because we are not testing that judgment in appeal. So we are not hearing that. We'll only interpret what is provided there. That we can do. per incurium wrongly decided, usually because the judge or judges were ill-informed about the applicable law. Applicable law, not the law. It was informed about the law was taken note of, but the applicable law was not informed.
My lord, applicable law is.
Applicable law is,
Nagaraj, my lord. What is
no,
written by-
applicable law is section 5 of the 78 Act had already been given its effect.
My lord, that has been.
So therefore, a further judgment, how to give effect to it is no longer the relevant issue. The learned single judge could have set aside section 5. Could have easily done it that provisions of section 5 is contrary to so-and-so paragraph of Nagraj, it is not sustainable.
That your worship will rule now, my.
Sorry, it could have been done. But the court cannot say that so-and-so provision is dormant. There is no judicial authority on any under 226 to declare a statutory provision to be dormant, except for the principle of casus omissus. I think it's casus omissus, not casus omission. Sorry. On the principle of destitute. Casus omissus is
Supplying.
supplying.
The omission part.
On the law, on the principle of destitute.
And
That is the only option available to a court.
here it was
That
followed.
is, means the provision was not applied by any authority required to apply it over a long period of time. So had there been no reservation in promotion given by the government of Assam, this issue would have come into play. But that's why I asked factually whether it is right or wrong.
Admitted position.
Once it is implemented, the act prevails.
Then the next question comes, my lord, why was it required to have a notification in 2014 and 16?
We don't know.
Unless you
We
require
don't-
the quantifiable data,
No, sorry.
that is the understanding of the government also.
Maybe.
Now finally, my lord,
Maybe if everybody wrongly understands, that doesn't mean we are also bound wrongly
I'll
accept it.
satisfy your worship, my lord, that is not a, my lord, wrong understanding of law. That's why, my lord, before referring to the Nagraj's, my lord, the law laid down by Nagraj, I'd like to draw your attention to the paragraph. Paragraph 62 and 63.
Of this equality.
Equality forum.
ইমান ধুনীয়াকে ইমান ধুনীয়াকে
Or paragraph 62, your worship may speak, my lord.
Not bound to provide. However, if the state wishes to make provision, which is permissible under, has to collect quantifiable data.
Paragraph 63, my lord.
Hmm.
Whether there is should be reservation for
See,
SC or
Mr.
SC promotion.
Sorry, the situation will be like this. Mr. Mojumdar will provide that if you want to go to Delhi, you can avail the Rajdhani Express. Okay. But the fact is, you are already in Delhi. You have already gone to Delhi either by Rajdhani or any other means.
As I understand is that,
So therefore, his offer, his provision that if you go to Delhi, in go by Rajdhani, has almost no relevance.
my lord.
So 62 possibly.
My submission will be with another example, my lord. Article 16(4)(a) and section 5 of the 1978 Act that gives a vehicle to the government.
That gives it.
A vehicle, a car, for instance. But to drive that car, you must have a driver and you must have petrol. That is the requirement that has been given by Nagraj, that to drive that, you have to have quantifiable data and a formation of opinion.
Very well. So therefore, we are again repeating the same thing. If you want to challenge section 5, you can do it very well on the basis of
I
Nagraj.
don't have any objection in the state having the car. I have objection that you cannot.
Your
drive it.
objection is most not relevant at all.
It is relevant.
It doesn't matter whether you have an objection or you don't have it.
No,
This is the situation. Mr. Chaudhary, please, we have to base our thing within the four corners of law.
Yes, my lord.
So,
That is what I'm trying to. impress
uh,
upon.
so how, without challenging section 5,
Challenge is not required to be made, my lord. We
what
do not challenge Article 16(4)(a). We have not challenged, nobody challenges it. Section 5, we are not
Okay, you are-
challenging.
yeah,
Then your lordship.
no, you can argue your own way.
Then your lordship may kindly come to, I'll read only two paragraphs from the sequel from judgment.
Paragraph 47, we have taken note of, 62, we have taken note of,
Now 67.
67.
Thus, from a careful analysis of the pronouncement of the apex court in M. Nagaraja, Suraj Bhan Meena, UP Power Corporation, what is discernible is that the quantifiable data regarding backwardness and backwardness has gone, my lord. Inadequacy of representation has to be echoed in respect of promotional cadres. It has been stated and restated by the apex court that requisite quantifiable data would be scrutinized in each case. In other words, the quantifiable data has to be both service and cadre specific. Then, my lord, what they discuss about the earlier one-man commission report. Then paragraph 68, it is true that following the law laid down by the apex court in Indrasani, SC and STs are deemed to be backward. It is further true that the concept of creamy layer is not applicable to SCs and STs. However, having said that, the court is of the considered opinion that the above factors would be relevant only at the time of initial recruitment. At the time of promotion, in the event of reservation is sought to be introduced, then assessment of backwardness of the said community having regard to their representation in the professional cadre would have to be carried out. Then paragraph 69, backwardness of SCs and STs which are the
Possibly the report of the one man. Cabinet decision. Mr. Chaudhary, if you come to para 10 of this judgment, why the writ petition was filed? Petitioner filed a present writ petition for quashing the report of one-man commission, cabinet decision, and the OM dated 2014. Okay. These are the limited purpose. Further, seeks direction to the reservoir comply with the requirement of 16(4)(a) explained in Nagraj before providing reservation. So before providing reservation, but we are in a situation where reservation had already been provided. So there is no question of before reservation.
I've seen the prayers of the the earlier petition, of course. The earlier petition. But this is one of these situation is same now also, my lord, because section 5 is already there. Section 5 was there when this petition was filed. Section 5 is still there. It is still there, but section 5 was also not challenged in the earlier petition.
As you want, the way you want to present it.
Hello, one just subject to. Supposing if the argument of my learned friend is accepted and a fresh exercise is done, another percentage is fixed. Which one is to be followed? The percentage in section 5 or the newly determined extent of percentage? It will lead to absurdity.
Section 5 not only
Percentage
provides
is
for,
what
not
is to be
only
done?
provides for percentage, it
Fixed
also
percentage.
provides for reservation. There shall be reservation.
Yes,
And shall be reservation at what? At 7%.
yes.
So there are two
Two
provisions.
provisions. Now, if the argument is accepted, that means after doing the exercise, another percentage has to be fixed. Now there will be 2%. Which one is to be followed? This will lead to absurdity. Otherwise, if they say, no, you do the exercise, but again follow the same percentage, then
Yeah, percentage will remain the same.
then what is the exercise required for?
Exercise is required for forming an opinion that you require whether the requirement of the promotion to in reservation in promotion is to be given or not.
Section
That
5
is the
says,
requirement.
as your lordship is indicating, section 5 says both reservation plus percentage.
Now, my lord, the last paragraph, my lord. Paragraph 74. I'll not read the entire.
Wait on I know it. Need to go for it. Yeah, the bench was university to the COVID now what you will balance or fix the about it's a happen.
Only one paragraph.
We requisition this bench on Tuesday, 2 o'clock.
Tuesday, my lord.
Tuesday, 2 o'clock. But Tuesday we'll have to finish it because repeatedly you can't go on asking for a.
Yes. Now can I read just one paragraph, my lord? Last paragraph, because there
It's
are.
another bench of it. No, otherwise, yes, one minute or two we can
One
take.
paragraph, I read, my lord, paragraph 74, last two, three sentences.
74 of equality forum.
Equality for my lord, 74 paragraph, your worship may company on page 737, 8th sentence.
Sorry,
On the, my lord, right hand side.
that therefore can be.
Though the state has, I'll start there, my lord, that is the 8th line on the left hand column of page 737.
7? No, you are reading a different book.
No, 74, my lord, paragraph.
I'm having
74.
a printout.
And I want to read from middle, my lord, only a part of it.
Uh,
It starts with as held in M. Nagaraj.
Though the state made provision, that one. Though the state had made provision for reservation by enacting, which is amended, implemented would depend.
Yes.
This line. You must be relying on implementation of the same.
No,
Would depend on acquiring. But this is, no, I got it.
Let us read the entire paragraph, my lord, then.
No, the court may have provided, but where is the provision of implementing a
Shall I read out?
here?
It's a part of paragraph 74.
Uh,
Let's just read out slowly, my lord.
uh,
Though the state has made provision for reservation in promotion by enacting 1978 Act.
Sorry, implementation of the same
Yes, my lord.
would depend on the acquiring.
Acquiring of quantifiable data with regard to two compelling reasons, which has to be carried out gather-wise in the context of the service where the gather is placed.
So now this provision, implementation of the same would become redundant as the act had already been implemented.
No more. What I want is that your lordship.
Just because there is a judgment thinking that it is not implemented, that will not alter the factual situation that it has already been
What I
implemented.
was trying to impress upon your lordship is that what is the kind of ultimate direction in this judgment? That is what I wanted to point out.
This direction is, one of the most perfect judgment. That this is also a requirement to that extent also it is very perfect. Given in the context of whether one-man committee report was under challenge. 2, the OM dated 2014 was under challenge. 2014 OM does not provide for any reservation in promotion. It provides for post-based. If you want to do it, you have to adopt the post-based. That is R.K. Sabharwal, implementing R.K. Sabharwal. The further line, petitioner further seeks a direction that before providing for reservation, this further direction was it was redundant at that stage itself because it is already a past happening that it has been given effect. So now on this incorrect presumption that it is not being implemented, the rest of the provisions are there. But that if the presumption is incorrect, the observations will also go.
Yes, my lord. To satisfy your.
I think from that point of view, we'll have
Your
to.
lordship's query, I understand, my lord.
Uh-huh.
To satisfy your lordship on that, my lord, I'll refer. to
Definitely will hear you. It's not that we are only putting the question.
Yes, ma'am.
That this appears to be so.
Tuesday time, 2 o'clock.
Tuesday, 2 o'clock, and we'll finish it off.
Yes, ma'am.
And because it will be a separate bench, there's no question of
Again.
earlier matters continuing or anything, sir. It will be exactly at 2 o'clock.
Or maybe, my lord, we can give a short, my lord, written argument, if that saves your lordship. In fact, my lord, written argument that was placed before the honorable chief justice is already there in the memo.
But that will be a thing we'll especially from the stand taken by Mr. Mojumdar, we'll have to go into that issue.
Yes. I'll try to.
Had he not taken the objection, it is okay. We would have glossed over it, but he had taken a specific stand.
I'll refer to their affidavit, matter what they say.
And we understand in 5026, you have assailed 2016.
Yes.
On the premises that it had provided for reservation in promotion.
It has provided for the procedure, which is contrary to the judgment in M. Nagaraj and other judgments.
Procedure.
It only provides procedure, ma'am. In fact, by the 2016 notification.
We'll read 2000 once
we'll
again.
Read that. By that, my lord, only how the quantifiable collection of quantifiable data has been left to the DPC.
That,
I'll show that, my lord.
that may have to go.
And therefore,
The DPC cannot determine quantifiable data.
and therefore, my lord, the formation of opinion. which
That
is-
particular provision may have to go. We'll look into it. Because quantifiable data is a state-wise exercise to be undertaken and not by an individual DPC before looking into a promotion. Possibly that is little.
And if it is relegated to the DPC, there is no question of forming an opinion, which is also a requirement. Opinion by the state.
Journal says it is.
So if it is so, what you are saying, that we may, there's a possibility of being interfered.
Can I give a written submission on my?
The argument of Mr. Ramkir Chaudhary in the Senior Council for the petitioner in WPC 5026 remains inconclusive. List for further hearing on 27/6. And we'll try to make it at 2 o'clock.